3-0.
3-0.
Yes, my lord. I am on interim, my lord. But if there is not available from other side, I have
Not available?
not available.
All right. 3-0 interim extended. Sydney
Applies.
office. 5th of August. Date.
August. I mean, May it please your lordship, I beg to mention item number 52 of supply list. Matter may be fixed at 2 p.m.
Speak a little louder.
Item number 52 of supply list.
Yes.
Kindly fix the matter at 2 p.m. I engage counsel in some other court.
At 2.
Lordship, at 2.
Okay, anyway, it's going to be 2 by the time it comes. Yeah, you make a mention then.
Please, your lordship. Lordship, with the consent of the other side, I beg to mention item number 48, lordship. 48. Conducting counsel, Mr. A.K. Gupta has some personal difficulties, lordship.
48. 16 matter. No, let it come up first. We'll see why is it being pending since last 10 years. Wait for your turn.
Lordship,
Yes.
lordship.
Okay, we'll see the file and then pass orders. Yes. Next.
Please, Lordship. I beg to mention item number 41, Lordship. In this matter, stay was taken yesterday, Lordship. Therefore, service is awaited. Step was taken yesterday, Lordship. Therefore, service was awaited.
Alright.
But another date may be fixed.
Submitted that steps were taken on 15/7/26 only. Let's list the matter again on date.
May I present, Lordship? Lord, I beg to mention item number 34, my lord. In this case, up-to-date CD was called for.
3-4.
34, my lord. Up-to-date CD was called for, probably not received, my lord.
ESPP. Not received. Interim is there?
Yes, my lord, interim.
Yes.
May it please, your Lordship. I beg to mention item number 35, 36, and 38, connected matters, Lordship.
Yes, what happened?
Lordship, in item number 36, your Lordship, through his order dated 27/5/2026, had directed this matter to be listed before Honorable Justice S. Jahan.
All right.
This has appeared before you today.
35 to 38.
35, 36, and 38.
What about 37?
37, 38.
37 is a separate counsel, Lordship. We are not engaged with 37. But it is a connected matter.
That was not rejected.
Huh? But order is there.
Order is there, Lordship. Your order dated 27/5/2026.
How like also 35 to
27/5/2026.
So we'll pass orders after. Just wait for a while. Yes.
May please, lordship. Lordship, beg to mention item 32, lordship. CD is not available, but the petition is on interim, lordship.
31.
Lordship, 32.
32, my lord, CD not received.
Not interim to come. Date.
6 of August, 6/8.
Deeply obliged.
May it please your
In
lordship.
which case the order is there. Just a moment, counsel who mentioned item 35 to 8.
Lordship, the order is there in item number 36, AB 366 of 2026.
All right, yes. 35 to 38. List the matter before the appropriate bench. S. Jahan J. As directed earlier.
Please, your lordship. I beg to mention item 28 of the daily list, your lordship. Lordship, the CD has not been received. That the matter be adjourned and interim be continued, Your Lordship.
All right.
CD no proceeding.
Obliged, Your Lordship.
May I please, your lordship? So I beg to mention item number 23, my lord. I may be allowed to withdraw this one.
23, your name?
You Khan.
Care of Mr. Yu Khan is dismissed as withdrawn. Yes,
Lordship, I beg to mention item number 4, my lord. I may be allowed to withdraw the petition, my lord, with liberty to
you are
file.
Mr.
SS Ahmed, my lord.
Hmm?
SS Ahmed.
S.S. Ahmed Lan dismissed as withdrawn.
My lord, liberty may be continued.
Liberty is required for a bail application. Next,
Obliged.
May it please your lordship, I beg to mention item number 33. Kindly pass over it for a day and fix it on another date.
30,
33.
43 case that you received, man.
any interim is there? When do you want?
Interim was any? No, man. Interim is not.
When do you want? When do you want?
Executive
Next week, any date next week.
22.
CDB retained.
May it please, Your Honorable Court. Item number 19, I respectfully seek the adjournment for the next case, next date. Item number 19,
What do you want?
adjournment for next date.
Right. Wait it.
Can take care of it.
May it be. This is a regular bail application, my lord. For it.
Hmm.
Lordship, I have, Lordship will deal with the case, my lord, the recovery of mobile phones inside the jail premises of
There is Sri
Bhumi
Bhumi.
district, my lord.
Already CD is before your lordship. Already CD is before your lordship, man.
Where I don't see it before me.
So that is Sri Bhumi, my lord.
Regarding
From
other
jail,
COA case.
jail inmates were supplied
Ah.
mobile phones, my lord. Yesterday also item number 1.
Now, where is the CD?
CD is before.
Submitted.
Yes. Yesterday's item number.
Oh, yes, the jail matter.
Yes.
Recovery of mobile phones, my lord. I am
Who are you? Subhasis
Subhasis
Ghosh. I
Ghosh.
think you are the main accused.
main accused. The
Really?
allegation is there, my lord. Flat common allegations, my lord, regarding the arrested 4 accused, my lord, who were arrested on 8/6, my lord.
They will fix for delivery of orders.
Delivery
along-
orders, my lord. My only humble submission, my lord, regarding him, my lord, regarding notice under section 35, my lord. He was served with the notice page. If your lordship takes down to page 22, my lord. In the notice, my lord, under 35, section 7 was added in the month of March, and notice was given to me on 2/6/26 through WhatsApp. But regarding section 7, there is nothing mentioned in this notice, my lord. I after receipt of the notice in my WhatsApp, I accordingly appeared before the police station, my lord. Thereafter, I was arrested in the checklist, even, my lord, citing the reasons for my arrest. They have stated simply, my lord, section 61, 323, 49, 262, my lord. There is not mention of regarding section 7, my lord, which is on
When was section 7 added? Before the
10th.
notice or after the notice?
prior to the notice, my lord. 10/3. 10/3/26, no, section 7 was added, my lord. 10/3, your lordship will find me. If your lordship takes down to page 26, your lordship, of my petition.
And notice is dated?
Notice is dated 2/6, huh? 2/6/26. 2/6 and
10/3/26.
2/6, your lordship, and section 7 was added in 10/3/26.
All right.
And in my notice, my lord, there is no whisper about section 7, my lord. Accordingly, I appeared, my lord. I voluntarily appeared, my lord, and I was detained.
Only in your notice it's not there.
Only the notice which was served to me, my lord, through WhatsApp. That
You
is,
don't know about the others.
I'm not about the others, my lord. In my notice, my
All
lord,
right.
specifically given to me, my lord. In my name is also there, my lord. Only that point. Highly obliged, my lord.
Yes.
May I please, lordship? The regular bail application, my lord, petition is 24 days behind the bar. FIR cause of action arose, Lordship, on 2/6/2026. And FIR lost on 17/6 after 15 days without any reasonable ground. My lord, at the very beginning, my lord, Ezaharkari alleged that his 11 numbers of cows are missing from the cow shed. Who was taken, that is not mentioned. And after 15 days, my lord, from the same locality, this petitioner name has been implemented. That and thereafter, my lord, another allegation being that 2 and 6, 2 and 3, extorted rupees 2,60,000. And thereafter, my lord, they threatened him to kill his life. And third, my lord, FIR is, my lord, page 8, my lord. So, my lord, on absolutely on the personal grudge, my lord.
But there is
FIR has-
recovery also from you.
Yes, yes. Nothing has been recovered from his.
Yes, one
watch.
cattle has been recovered, it says, as per the FIR.
FIR is page 8, my lord.
As per the forwarding,
Forwarding is page.
page 16,
Page 16.
Until now, only one recovered. In
one
10
recovered.
One recovered page 18, my lord.
Hmm.
And that was recovered from the possession of one Shoman Ali.
Sorry, where is that?
Yes, at page 18, my lord, page annexure 3. Relevant portion is page 19, my lord.
lead to recovery, man.
Hmm?
During the course of investigation, reliable source inquiry lead to the recovery. Initially, the present petitioner arrested and thereafter, my lord, that stolen cow was recovered.
Already 23rd.
Yes.
Public.
May it please. The such case, my lord, the petitioner's name has not been included in the FIR, my lord. In fact, not FIR has been specifically lodged against on Zakir Hussain, my lord.
And not in
And
the
this-
FIR, but what about the charge sheet?
In the charge sheet, my name has been included, declaring the petitioners to be
TCR.
absconders.
Can copy of TCR.
Notice also has to go. Bosco is.
Notice to respondent.
The case is fixed on 5th of August, my lord, before that, my lord.
All right.
Huh? 5 তারিখত কেসটো ফিক্সড আছে আগতে
31 December.
31 realized before 5th of August.
prior to that, my lord.
That is your prayer. It should be fixed
Today-
before 5th of
today we are
August.
16, my lord. Or 25 or 26, my lord.
25, 26 Saturday.
And don't waste our time haggling over dates. Yes, next item.
5 is also, my lord, postponed. Investigation going on.
May I please, Your Honor? POCSO is the lawsuit. Notice may be issued.
Same order.
Lawsuit and CD may be called. Deeply only.
CD, you cannot TCR.
37.
Deeply only.
Please, your lordship. This pre-arrest bail application, lordship, and there is the dispute between the informant party and the present petitioner regarding in connection with a small village road, lordship. And the road is using by the petitioner's side and the other villagers, lordship, about 50 years back, lordship. And the landlord is different person, lordship. And I'm coming to lordship, and the FIR page number 12, lordship, is the informant FIR. And our FIR is also, lordship, there, and the informant FIR will find page number 12. And same sets out of same incident, lordship, both the two FIR has been lodged in the same date, same time, lordship. Both the FIR is registered in same section, lordship. And as per the FIR, lordship, the petitioner party got more injuries, lordship.
Which is the FIR of the present case.
Lordship, page number 12, lordship. Translated copy, Lordship. 12 operating person, next, page number 13. There are 11 numbers of, including the tab for 3. And same section, both the FIR is registered, Lordship. And our FIR is page number 23, Lordship. Page number 23 is our FIR. And Lordship, 23 is our FIR, Lordship.
Page?
Page 23, Lordship. Translated copy. This our FIR lodged by the Marjina Parvin, Lordship, is the one of the accused and his wife, Lordship. Admitted some market is there, Lordship, but the section is, Lordship, is will not come, Lordship. Our case number is, Lordship, 197 and the informant FIR is 196. Lordship, kindly come to page number 34, Lordship, the one complaint, Lordship, and that's the before the District Commissioner Borpeta, Lordship, regarding the road, Lordship, and in the year of 2020. And subsequently, Lordship, on that basis, Lordship, that is the owner of the land, Lordship, only 15 lessons, Lordship, the one Abdul Samad, Lordship. And this is the complaint against this land. And subsequently, Lordship, and page number, Lordship.
Anyway, allegation is regarding causing of grievous injury, attempt to murder. We have
No,
to see the
Lordship,
CD.
our FIR is same Lordship.
No,
And
no.
for a moment, Lordship, for a satisfaction, page number 42, Lordship.
Just because your FIR is earlier in point of time doesn't mean anything. It can mean the converse also. That they were injured, so they could not go to police station. You attacked them and went to the police station and filed an FIR. It can mean that also. Just because it is earlier in point of time by a few minutes doesn't mean anything. CD.
Lordship, and the petitioner number 1 is a 63 years old person, Lordship. I'm very specifically mentioned only for him, Lordship. And he is the person, Lordship, is partly, Lordship, physically handicapped, Lordship. And about 20 years back, Lordship, he got an accident, Lordship, and he could not move properly, Lordship. But his name is also in the so only for his this petition number 1.
Is this
Can it
any
be?
certificate?
And about 20 years back, he got an accident, Lordship. This paper is
Oh.
not right now, Lordship. 63 years only for him, Lordship.
Without any document, what should we do?
And otherwise, Lordship, only
Give a short date.
Lordship, and the other,
It's not as if you were waiting there to be arrested.
Lordship, the other,
Well-
Lordship, and bail petition is, Lordship, pending for, and 15 AV, Lordship, 1534, and that is next date is fixed on, Lordship, 22/7, Lordship.
Hmm.
AV number 15,
List along with AB number.
1534, 26. Next date on 22/7/2026, Lordship.
Interim is there in that case.
One is interim, Lordship. One person is interim, Lordship.
Yes, next.
Obliged, Lordship. Obliged.
Please, Your Lordship. So, appearing on behalf of 3 Decker, due to personal difficulties, unable to reach the court today. FIR is at page number 10, Your Lordship. FIR date back to 2020-22. Person died by hanging, and the allegations are of abatement to suicide. Your
Charge-sheeted case.
Lordship. Charge sheeted.
Can copy.
Deeply obliged.
May it please your lordship. Once the pre-arrest bail, my lord, your lordship will find the FIR, my lord, at page 9, my lord. May I read, my lord?
Who are you?
My lord, your lordship will find at page 10, my lord, the main accused Anwar Hussain, my lord. My lord, he got arrested, my lord. That your lordship will find at page 16, my lord, his forwarding report. My lord, that Anwar Hussain has been arrested, my lord. That is at page 16, my lord. Thereafter, my lord, another person have been arrested, my lord, that your lordship will find at page 19, my lord. That is, my lord, Motiur Rahman, my lord. Page 19, my lord. Lordship got it, my lord.
What is your involvement now?
My lord, that's why I'm coming, my lord. Lordship may kindly turn to page 20, my lord, the grounds of arrest, my lord. Grounds of arrest number 1, my lord, that during the course of investigation, it has been revealed from witnesses' statement and other collected evidence that the accused Motiur Rahman knowingly procured and supplied the pregnancy termination medical kit to the minor victim at the request of the principal accused, Anwar Hussain. His act was not incidental but constituted active assistance in the commission of the offense, thereby attracting the offense relating to abatement and criminal conspiracy. And my role is, my lord, I am a, my lord, employee of that pharmacy, my lord.
That is Motiur Rahman.
Yes, my
He
lord.
procured.
My lord, the
You
main.
are Afzalur Rahman.
No, my lord.
Huh?
The main accused is Anwar Hussain, who got arrested, my lord. He got the pregnancy kit, my lord, through this Motiur Rahman. And Motiur Rahman procured the same from a pharmacy, my lord. In that pharmacy, I am an employee, my lord. The present petitioner.
Where is that?
Yes.
Where is that in this page 20?
20, my lord, that is not there, my lord. But he said, my lord, that during the course of investigation, this Motiur Rahman has procured this, my lord, termination medical kit, my lord.
So that Motiur is arrested.
And that Motiur is arrested, my lord. I am the, my lord, employee of that pharmacy, my lord. At best, my lord, it may be a case of, my lord, under the drugs and cosmetic, my lord. I have sold, my lord.
Yes.
Otherwise, from the forwarding report of the co-accused
So
person,
is not directly.
yes, against him, my lord. Otherwise, my lord, from the forwarding report of the co-accused also, his role is well, exactly, my lord, that is
Seller.
regarding the involvement of the present, how he is involved regarding those aspects are not there in the
Nothing is discernible.
discernible.
Mr. Dr. Learned Counsel for the petitioner and learned additional PP. An application under so and so. The allegation as per the FIR is that the main accused of the case, namely Anwar Hussain, had physical relationship with the victim aged about 17 years, as a result of which she became pregnant, and of the para, the main accused, aforesaid main accused, along with another co-accused, Motiur Rahman, who is alleged to have supplied the pregnancy kit, termination kit, the main accused, have already been arrested. Full stop. It is submitted by learned counsel for the petitioner that the present petitioner is only an employee of the pharmacy where from the said termination kit was allegedly purchased. Could we dispose of?
This is POSCO is there, CD may be called for.
Alright. Yes, POCSO is there, so call for the CD. Notice to the respondent number 2. Provided that in the event of his arrest, the petitioner shall be released on interim bail of ₹20,000 with security of like amount to the satisfaction of the arresting authority incur. Further directed that the petitioner shall cooperate investigation. Is taken on
29/7.
I have to appear, madam. I have to appear
yes
Within
petitioner to appear within a period of
within 10 days. I am obliged.
May it please your lordship, my POCSO 8 is there, madam.
now.
Notice may be issued when a short date may be fixed, madam.
CD and notice to respondent.
Obliged, madam.
28/7.
This is in pre-arrest bail application, lordship. Where this case, lordship, the one accused already grant interim bail, lordship. And it is page number 18, lordship, by your lordship. One petitioner already grant bail, lordship, in the different petition, lordship, page number 18. I humble prayer, lordship, the petitioner is a very young boy, lordship, and some dispute is all the informant and the petitioner are the same family, cousin and uncle, lordship, nephew and uncle, lordship. And some dispute is going on the date of each celebration, lordship, regarding the sacrifice, lordship.
Where is that affidavit?
Affidavit is, lordship. This that is fixed on 21, lordship, for CD. So this is same protection, maybe, lordship.
Your name is Osman.
Osman, lordship, and is the nephew of the informant, lordship.
Huh?
He is
He is the
accused,
nephew of the informant, lordship.
accused number 1 in the FIR. Mangani bhai.
They said affidavit is specific to Baharul and Suleiman. He said they did not do it. That means you did it.
Yeah, till then, lordship, the
But
CD,
till
lordship,
then,
very young.
you cannot claim parity. Rather, this affidavit weakens your case.
The death matter was fixed on my lord
21.
21/7.
21?
21/7.
All right, 21/7. All right.
Then, lordship, and if anything is come, lordship.
5 days only. 21.
Biplab,
Along with
Along with my lord AB 1388/26.
1388.
no need to call or anything. Just is this matter along with.
Published, lordship.
Wait, Mr. Lordship. The petitioner before your lordship is a employee of the Bajaj Finserv Limited, lordship, and he came into a contract with one Sinmoy Gogoi for financial transaction of rupees 25 lakhs, lordship. An entire amount has been paid, Lordship, in the meantime.
What is this PhD thesis you have submitted?
Lordship, all the transactions.
My lord, vital page is your lordship, page 255, last page of the my lord petition, my lord. There was no FIR,
Page?
my lord, registered against the present petitioner. Initially, he approached before the session court.
Page?
250.
Last page, my lord, of the petition, my lord, 255.
Transaction into the public.
Now again, he approached before this.
So you're the same person.
Yes, Lordship. After the furnishing of the report, Lordship, the petitioner has been harassing against by the again by the police authority of the Sibsagar police station. Lordship, my prayer is that at this stage, status report may be called. No coercive action may be taken against the petitioner. He's ready to cooperate with the investigation if there is anything.
Page 7, paragraph 6. This one, my lord. Only because, my lord,
Heard learned counsel for the petitioner and learned additional PP. Call for a report from the IO as to whether any. From the OC, what police station, Sibsagar?
Sibsagar police station.
Yes, as to whether any case has been registered stroke under inquiry as against the present petitioner, Wadur Rahman Bora. Is made clear that in the absence of any complaint, the petitioner shall not be harassed by the police in any manner. List again on so and so.
23-7, 23-7,
28 of November.
28-7.
28. Lordship.
Legal Lordship. There is a pre-arrest bail application, Lordship. Your Lordship will find the FIR is at page 9, Lordship. FIR name accused number 283 before your Lordship as petitioner's Lordship. The
Yes.
similarly situated person, Lordship, has approached this honorable court, Lordship, and they were granted interim bail, Lordship. Your Lordship will find the order is at page 27, Lordship. Lordship, they started construction on a government land. Some local people gathered there and objected to the construction made by the Lordship informant side, Lordship, because Lordship, they were selling alcohol from the illegally from the said shop, Lordship. And then it's some local people gathered there and some altercation happened between the informant side and the local people, Lordship, resulting lodging this FIR, Lordship. Because they also made allegation against two women, Lordship, Jerifa Kaman and Tutu Kaman.
When is this fixed now?
Petitioner name is Paplu Payang and Tulsi Payang,
37, all right.
2 and 3. Petitioner number 2 and 3.
Hard learned counsel for the petitioner and learned additional PP. Is this matter again on 37/2026 along with AB 1477 of 26. Having regard to the fact that the similarly situated co-accused persons petitioners in the aforesaid case have been granted the privilege of pre-arrest bail. It is provided that page 29, para 6, names will change. Same conditions.
Highly obligatory.
This is a NIA matter.
The dispute in this matter has been, settled out of court. And they have executed a deed of compromise. And I filed an IA to take that in record and dispose of the matter in terms thereof. But IA may not be on the record because I have filed it yesterday. So
This revision was against the order of what?
Against the order of the appellate court.
Appellate.
Actually, I am the complainant. The check was of 15 lakh rupees. And
So what happened in the trial court?
in trial court, the
Convicted.
conviction was given,
Yes.
2 years imprisonment as well as 20 lakh
Then
rupees
appellate?
compensation. Appellate court also upheld.
upheld.
Also upheld. So twice it is affirmed, and they have come for revision. Now, Lordship, in 10 lakh rupee, because it is between the maternal uncle and the nephew, so a settlement is reached, out of which 4 lakh rupee is paid to me.
Already paid.
Already paid 4 lakh rupee on the date of the agreement.
Yes.
And after that, the agreement is made in such a way that within 3 months, another 3 lakhs, and in the next 3 months, another 3 lakhs. So that is the term. So Lordship may keep this on record so that later on, if there is an issue, this undertaking can be can be taken and
So let the IA come then.
Yes.
yes.
Submitted that an IA has been filed in connection with the present case, but the same is not on record. Registry is directed to list the case along with the aforesaid IA. It is numbered.
Yes, number.
Being IA number.
I'll give the number. I'll give the number.
Give a date.
29th of the
This is a complaint case where cognizance is taken by the learned trial court. My lordship, thereafter they approach the learned trial court to quash the proceeding. Which is ordered dated 19/9/2023, page number 19. But his prayer was rejected. In this case, some defamatory article was published in the newspaper Assamia Proceedings. The petitioner is the owner of the Assamia Proceedings, so he is not liable for the a publication of any defamatory article in the newspaper.
So notice is complete.
Yes, Lordship. I am appearing for response number 2, Lord. Scan copy is also in the.
What is the impugned order?
Is it page 19, Lordship?
Page 9.
As well as page 18, Lordship.
In order of cognizance.
Yes, so what is wrong with the order?
In 19,923, in the last portion, he is there for application for quashing the proceeding. What the honorable court is, the term rejected his prayer. Who is his order dated 19/9/2020.
What is wrong in this order? Quashing before the trial court.
My lordship, our High Court's order is that with the quashing of complaint as per Press Registration Act, Section 7, the printer, provider of printing press petitioner neither being editor, though the petitioner is not the.
At best, you could have prayed
publisher.
for a discharge if it's a warrant tribal case, warrant procedure case.
It's our High Court's order, my lordship.
So Lordship, if the trial,
He is the
then
owner,
the
my lordship.
petitioner may also be represented in the trial court. So, and whether his involvement is there or not, Lordship, it is matter of trial. At the initial stage, certain, and to my response submission, Lordship, in order to 19/9, there is nothing illegal because trial court does not have any power under 482. Of the
No, but leaving aside that, she has challenged the order of cognizance also.
is there, Lordship.
All right, fix a date for hearing then, since everything has been received. Third learned counsel
So, Lordship, can it be after 7th, Lordship?
and learned so and so. The appearances are complete and here has also been received. And this is the matter for hearing on.
Published.
Please, Lordship. Lordship, I need to request 1 week time for to file a petition challenging that impugn order that charge sheeted. I have to enter process of the quashing in process.
The charge sheet is the outcome of the FIR.
Yes,
When
sir.
FIR is challenged, there is no point for challenging separately the FIR charge sheet, my lord.
And it-
What the charge sheet was filed in 25/12/2025, and case was filed in 25/12 after 2 months. So it was already in process. There is no
So we
point
came to
for
know after
staying
that
the
when
order
they have
challenging
filed
the
that affidavit that charge sheet has been filed. We came to know that time only. Lordship.
15 lakhs agreement was made, 19 lakhs he took, out of 19 lakhs, 4 lakhs, he worked for only 4 lakhs. I am seated for under 15 lakhs.
The petition is at Bangalore for his treatment. Lordship. I think request only 7 days to file the petition.
It is the outcome of the FIR, charge sheet is the.
Yes,
I
outcome
have
of the affair.
submitted copy of the charge sheet.
There is no necessity of challenging separately because once if the FIR is quashed, everything, every subsequent development also stands quashed.
Supreme Court case I have already submitted, it is in
But if the
record.
question should
That
be
every case is size cannot be caused, my lord. Only there is no item materials in the FIR, then it can be caused. So that is followed in
say
the
nothing.
under
Lordship, I
21
think
Supreme
request only
Court.
7 days time, Lordship, to file that
Bhajan
petition.
last case, it is a leading case of Supreme Court, I am submitting in the record last week, my lord. Last date. So there is no point for proceeding in this case, my lord. The He has seated me and police says he has filed my case earlier, but there is no materials. The case filed by him against me. I have filed later, but finding materials, charge was submitted. 418, additional matter, the sittings. Under case matter, the 1920.
I record only 7 days to file that petition, Lordship. He is at Bangalore. He is coming today, Lordship. I need 7 days to file that petition.
All right. Next Thursday.
Yes, Lordship.
The prayer of learned for the petitioner. Further 7 days time is granted to file appropriate application as prayed for. List again on.
If there is an interim order, may continue, Lordship.
Continue till the next date.
8 piece of this. 8 piece of this.
Maybe fix on 28, matter. Next day, next week, I may be absent.
28
July. 27 or 27, next week I shall be out of state.
20. Published.
May it please. My lord, petition assailed the order dated 23/3/2026 passed by the London Trial Court. I'll take your lordships, which your lordship will find at page 25. Lordship got it. Yes. The complainant is present. The accused is absent. The learned advocate for the accused by petition number so and so stated that due to ill health of the accused, he is absent today and has prayed to dispense with his appearance. Prayer is allowed. The learned advocate for the accused by petition number so and so has stated that the accused has all along been diligently contesting the present case. However, on 18/3/2025, the previously engaged counsel of the accused person, without any instructions from the accused, submitted before the court to close the evidence of the PWs, for which this court closed the evidence of the PWs. The accused was never intimated about that order passed by this court, closing the defense evidence. Due to such orders, the accused will be severely prejudiced as will not be able to rebut the averments made in the complaint. Accordingly, the learned advocate for the accused has prayed to recall the order dated so and so, whereby the evidence of defense was closed, and to grant one opportunity to the accused to examine himself as defense witness. Then I skip this para. On going through the case record, it appears that since 27/11/2024, the accused remained absent through the case was fixed for DW evidence. Due to absence of the accused on 4 consecutive dates, a non-bailable warrant of arrest was issued against the accused, and on issuance of non-bailable warrant of arrest, only the accused appeared before the court on 13/6/2025 and prayed to allow him to remain on his previous bail and to recall the NBWA. The accused undertook to remain present on all the subsequent dates for which the prayer of the accused to recall the non-bailable warrant was allowed, and also allowed him to remain on his previous bail. But since then again the accused remained absent on the next 3 consecutive dates, for which again the non-bailable warrant was issued against the accused. Again, on issuance of so and so, the accused appeared before the court on 20/12/2025 and prayed to allow him to remain on his previous bail and to recall so and so, and again undertook to remain present on all the subsequent dates for which the prayer of the accused to recall the was allowed, and also allowed him to remain on his previous bail. But again on so and so, the accused remained absent before the court. The complainant has already argued the matter, and the case is pending at the stage of argument from the side of the accused. Finally, on 11/3/2026, the accused appeared along with his new set of advocates, and today the learned advocate for the accused has filed a petition number so and so, Though it is written in the petition that the accused has all along been diligently contesting the present case, but from the above conduct of the accused, it appears that he is trying to cause delay in disposal of the present case. The newly engaged learned advocate so-and-so has stated that the previously engaged advocate for the accused inadvertently submitted to close the evidence of PWs. But from the conduct of the accused, it appears that there was no inadvertence on the part of the learned engaged advocate for the accused, and the conduct of the accused compelled his learned counsel to pray for closure of evidence before the court. Now, my lord, we are agreed by these. My lord, the conduct of my client definitely not good, my lord, because my lord, your lordship will find he's a habitual substance abuser. So therefore, he has been suffering from mental disorder also. Now, supposing the learned counsel was not getting cooperation from him, it is up to him, my lord, he could have withdrawn his wakalatnama, withdrawn from the case. But he should not have made a submission that the DW evidence may be closed. As a result, my lord, what happened? As your lordship is well aware, under section 139, my lord, the presumption is drawn against the accused person that if he doesn't make any rebuttal evidence, then it will be accepted that whatever has been stated is correct. Now, because of that, we filed an application to recalling that order. Your lordship will find that order at page. The order which we, at page 21, your lordship kindly see. Order dated 18/3/2025. The learned advocate for the accused with petition number so-and-so dated today has stated that the accused as well as his witnesses are unable to appear before this court due to their ill health, for which the learned advocate has prayed for dispensing with the personal appearance of the accused today and has prayed for closure of the DW. Now, that submission is not correct because he has been ousted from the case. Both the prayers of the learned advocate of the accused is allowed. Now, when we have been engaged, my lord, we came to know that shortfall in the case. We filed an application which your lordship will find at page 22. The next page your lordship will find. The application under so-and-so of the BNSS. The aforementioned case is fixed today for argument before this honorable court. The accused has all along been diligently contesting the present case and has never intended to delay the aforementioned proceedings. That however, on 18/3/2025, the previous counsel for the accused, without any instructions from the accused, submitted before this honorable court that the presence of the accused may be dispensed with in his absence due to his ill health, and further inadvertently submitted the accused evidence may be closed, and considering the said submission made, this honorable court had closed the evidence of the accused. The accused was never intimated about the said order passed by this honorable court by the previous counsel in regard to closing of the defense evidence, and due to such order passed, the accused will be severely prejudiced inasmuch as will not be able to rebut to the averments made in the complaint filed by the complainant. Further, the recalling of the evidence of the accused will further ensure just and fair adjudication of the entire proceeding and would ensure complete justice to the parties to the proceedings. Now, my lord, we are aggrieved against that. My lord, in that case, what will happen, my lord, I cannot rebut, and whatever has they have stated, that will be taken against us. So this is the short point involved in this case. And my lord, I want to cite a decision of the appeals court on this issue. I'll just take to your lordship's 2 paragraphs from this decision. Your lordship can look at paragraph 14, my lord. Paragraph 14 and 17.4. I'll read out paragraph 14. A conspicuous reading of section 311 CRPC would show that widest of the powers have been invested with the courts when it comes to the question of summoning a witness or to recall or re-examine any witness already examined. A reading of the provision shows that the expression any has been used as a prefix to court, inquiry, trial, other proceedings, person as a witness, person in attendance, though not summoned as a witness, and person already examined. By using the said expression any as a prefix to the various expressions mentioned above, it is ultimately stated that all that was required to be satisfied by the court was only in relation to such evidence that appears to the court to be essential for the just decision of the case. Section 138 of the Evidence Act prescribed the order of examination of a witness in the court. The order of re-examination is also prescribed calling for such a witness so desired for such re-examination. Therefore, a reading of Section 311 CRPC and Section 138 Evidence Act, insofar it comes to the question of a criminal trial, the order of re-examination at the desire of any person under Section 138 will have to necessarily be in consonance with the prescription contained in Section 311 CRPC. It is therefore imperative that the invocation of Section 311 CRPC and its application in a particular case can be ordered by the court only by bearing in mind the object and purport of the said provision, namely, for achieving a just decision of the case as noted by us earlier. The power vested under the said provision is made available to any court at any stage in any inquiry or trial or other proceeding initiated under the code of for the purpose of summoning any person as a witness or for examining any person as in attendance, even though not summoned as witness, or to recall or re-examine any person already examined. Insofar as recalling and re-examination of any person already examined is concerned, the court must necessarily consider and ensure that such recall and re-examination of any person appears in the view of the court to be essential for the just decision of the case. Therefore, the paramount requirement is just decision, and for that purpose, the essentiality of a person to be recalled and re-examined has to be ascertained. To put it differently, while such a widest power is invested with the court, it is needless to state that exercise of such power should be made judicially and also with extreme care and caution. Then, my lord, I will take your lordships to paragraph 17.4, which your lordship will find at 17.4 million. The exercise of power under Section 311 CRPC should be resorted to only with the object of finding out the truth for obtaining proper proof for such facts which will lead to a just and correct decision of the case. My lord, under Section 311, for the ascertaining the truth and fair trial, my lord, that evidence ought not to have been closed. That too, my lord, is a submission made by a lawyer without the instruction of his client. And another decision, my lord, that is although on the merit of the case, but still then I just like to highlight it. In this case, my lord, that is in regard to merit, your lordship may not like to go into. Now, what happened, my lord? He has said, he has given loan. Now, my lord, he did not in his evidence say how he has managed the source. And then in what way, my lord, I have paid to him, whether it is by check or by NEFT, nothing is there. In his evidence, he did not elaborate. To that effect, this paragraph will give some light, my lord, in paragraph 14, my lord. It was held that when evidence elicited from complainant during cross-examination creates serious doubt about the existence of debt and about the transaction, and the complainant fails to establish the source of funds, the presumption under Section 139 is rebutted and the defense case stands provisionalized. So therefore, my lord. How is that relevant for the present purpose? No, not for the present purpose, my lord. That's why I'm saying it's regarding merit, your lordship may not like to go into. So therefore, the first submission is that this client was not knowing that the submission was made to close the evidence. My submission solely will be on that, my lord. And the appeals court also said in a judgment, my lord, in that also I like to take your lordship's the decision of the appeals court that they will have to, the drawer will have to adduce evidence to rebut the presumption. That your lordship will get at paragraph 33. Para 33 reads like this: a meaningful reading of the provisions of the Negotiable Instrument Act, including in particular section 20, 87 and 139, makes it amply clear that a person who signs a check and makes it over to the payee remains liable unless he adduces evidence to rebut the presumption that the check had been issued for payment of a debt or in discharge of a liability. So therefore, unless I rebut saying that rebuttal evidence is not there before the court will presume that whatever he has stated, that is a gospel truth. And that can be used against me. It is understood. You have to rebut the presumption one way or the other. Right. So that chance has been, my lord, here is different. My lord, here, as your lordship has seen, my evidence has been closed on the submission made by the counsel. Yes. And it is the presumption that whatever submission is made is on the instruction of the client, unless you can prove show otherwise. Otherwise, in every case, your lordship is right to that extent. Somebody will come and say, no, I didn't. But then your lordship kindly see, in order to see whether there is a fair trial. In respect of that, my lord, the evidence ought not to have been closed because the client was not there on that day. He was absent. And if he was present and that submission was made, then whatever your lordship is saying is very correct. Now, client was absent and the advocate is making a submission, evidence may be closed. So in the factual background of this case, my lord, the closure of the DW evidence, it was possibly, my lord, in my respectful submission, was not correct. Because he has been deprived from the right of rebuttal. So to that extent, your lordship kindly give us that relief so that we can appear and make our rebuttal evidence. So for his conduct, my lord, I have seen, as he's rightly I have stated with your lordship, he's a, my lord, abuser of drugs and he still is suffering. We are supposed to have sympathy because he is a drug addict. That it appears from the records, my lord, and for a number of times, my lord, he did not appear.
What you will kindly see, the C13 statement was recorded long back in the year 2024, my lord. Thereafter, my lord, the case was posted for DW evidence. Subsequently, my learned senior colleague has already read out that particular order, my lord, 23/3/2026, whereby the conduct of the accused has been reflected on various occasions. On 2 occasions, my lord, he intentionally remained absent and NBW has been issued. Thereafter, it was recalled, my lord. And all of a sudden, my lord, after 2 years, almost after 2 years, he wake up and he comes and files a petition before the learned court, my lord, that the evidence was closed without his consent, my lord. And the lordship will kindly see that petition, my lord, Annexure B, page 20, my lord, that the application has been filed under the provisions of section 348. 348 deals with the recalling and re-examination of the witness, my lord. And here their prayer was to recall the order dated 18/3/2025. Once a criminal court passes an order, my lord, the criminal court becomes fantas officio and it cannot recall its own order, my lord. So the petition is itself not maintainable under the provisions of the law, my lord. Lordship, for the sake of DW, the case has been dragged for last 2 years. How much the court will wait, my lord? And now he is saying that it is not as per his instruction and as per their grounds, my lord, whatever they have taken, it has been specifically mentioned that he has been suffering and he was under treatment from the month of July 2025 at Gauhati and Dibrugarh. Apart from the July 2025, my lord, that has been explained. But prior to that, my lord, the evidence was closed long back in the year 2024, my lord. The case has been fixed for DW evidence in the year 2024. From the 2024, my lord, since July, why he could not appear, that was not been explained, my lord. Under that circumstances, the court has rightly rejected the petition, my lord.
When was this 313 taken?
2024, my lord, 11 of no? Month of I think my lord, it is month of November 2024, my lord.
All right. On that day, he was present definitely.
Yes, my lord.
Yes. After that, what happened?
After that, he remained absent, my lord. Case was posted for DW, my lord, and he remained absent. And thereafter, finally, on 18/3/2025, NBW was issued, my lord. That was subsequently recalled. He undertook that he will appear regularly, my lord. Thereafter, he again remained absent, my lord. And on 18/3/2025, he was all along represented by his counsel, my lord.
From 18/3/25.
Lordship, on 18/3/2025, the petition was filed by his counsel that they do not want to adduce DW, my lord. Accordingly, the learned court, my lord, closed the evidence, my lord, and the case was posted for argument. And already on 6/5/2025, my lord, the complainant already advanced their argument before the learned trial court, my lord. The case has been dragged for at the stage of DW, my lord, since 2024 to 26, my lord. So, my lord, whatever order that has been passed, my lord, that is the order dated 23/3/2026 that has been rightly passed, my lord, considering the conduct and entirety of the case and the prolonged delay made in the case due to the conduct of the accused, my lord. That is the petitioner. So far, the rebuttal of presumption is concerned, my lord, in Catena of Judgment, Honorable Apex Court has stated that whatever has been elicited from the mouth of the complainant, that can also be used by the accused to rebut the presumption, my lord. It is not that in every case they have to step into the witness box and adduce their evidence. Respectful submission, lest I leave it to your lordship, my lord. Kindly consider the conduct and the prolonged delay caused in the case due to the conduct of the accused. Treatment part, lordship, that has been explained from the month of July 2025, my lord, in the grounds taken by them, my lord. Prior to that, that has not been explained. There is every likelihood, my lord, if their petition is being allowed, again they will carry out the same exercise, my lord, and the case will be again delayed.
Yes, anything else?
My respectful service.
Why 3 petitions?
The same point involved in all.
Between the same parties, my lord, check amount are different, my lord. 3 checks involved in the case, my lord. Between the same parties. 3 cases has been filed. Same order in all the cases, my lord.
The point involved is the same.
CAB.
Obliged.
Hearing is.
Let us
Let me finish my part. They will argue later on, my lord.
wait for some time. We'll take up the other matters first. This is hearing matter.
Second half, my lord.
We're not saying second half. Just let us finish this bail matters first.
Please, your lordship. Then POSCO matter, my lord. Since service has been completed. Service complete has been. 20. Bilasi Parato.
Yes, sir. Any report?
We have received the information that service completed, my lord.
As per instructions received, is submitted by learned additional PT that service on respondent number 2 is complete. However, none appears. So is appointed as amicus curiae to represent respondent. Served upon. Newly appointed. It has already been received. Scan copy. List. On. It.
Also, amicus curiae has been appointed, my lord.
Yes,
Amicus-
yes. Give the list.
The list. Amicus curiae list.
ৰাখি দিয়ক মই পিছত চাই পেলাই দি দিম নেক্সট কেছ মাতিটো
Debit হয় দাদা. He is also amicus. He is also present.
Your name?
May I please your lordship, item 21. CD was called for in this case.
But here charge sheet submitted.
Lordship, although charge sheet has been submitted, this Honorable High Court has already observed that in some cases where further detention is not necessary, bail may be granted, Lordship. Detention if not necessary.
Therefore, let us know what is the case is about.
Lordship, what happened? A truck with 680 cartons of beer carrying from one place to another. Suddenly, Lordship, what happened at night? The driver decided to stay because of night. And at that point of time, at night, what happened? Some persons have committed theft of that beer. Later on, some portion of that beer recovered in Azara, Lordship, Azara under jurisdiction of Azara police station. And this person, the petitioner, has been arrested, Lordship, on 8th of June. He has been forwarded. Almost 40 days completed, Lordship. Actually, 39 days today. Almost 40 days completed. And Lordship, all beers are recovered.
Empty or full?
Full lordship. Empty beer lordship, there will only
Some cartons
remain.
recovered as per my lord, page 11.
Cans.
Some cartons recovered, my lord. And others suspected that the present petitioner, my lord, has sold it.
Maybe lordship, during the transportation, some beers have been eaten by or drunk by the theft, lordship. Now, lordship, for 60 days offense, 40 days he is remaining behind the bar. So lordship may kindly grant me bail, lordship.
You appear there.
Lordship, an Andolan is going on in CJM court,
It
lordship.
has been withdrawn for your information. It was withdrawn. We got the message at 12. It said.
My lord.
12.
Don't assume that our ears and eyes are shut after 5 o'clock. Because it is not just a petty theft, it's a whole consignment. How much recovered?
My lord, here not information regarding this, my lord. Yeah, but cartoons are, my lord, 680 numbers, my lord. Huge stuff.
Huge.
My
So
Summer days, lordship, some
40 days is nothing.
lord.
It will be a huge quantity. Monetarily, it will be a huge quantity amount.
Truck,
Use truck,
full
lordship.
my lord. Truck and 680.
During transportation, some beers may be drunk, lordship, by the theft.
No, no, not that. Lady ATM. And file fresh bill.
Appear there. Apply for bail. Appear means what? You apply for bail there since charge sheet has been submitted. Otherwise, we call for the TC.
Yes, lordship. LCM may be called.
CS has been submitted by number so and so. Can copy of TC.
Third August. Charge sheet number 67 of 26, dated 27/6.
Mandatory period over.
But mandatory after
What
charge sheet
charge
is
sheet is already.
May I please, lordship, 483 application, your lordship. I am behind the bar for 76 days as on today, your lordship. I was arrested on 1/5/26. There is sections 74, 75 2 of BNS, reduced section 10 of POCSO Act. Those sections will be of 60 days of mandatory, your lordship. So I am behind the bar for 76 days, your lordship.
Charge sheet submitted.
I will have to take instruction, my lord.
Get the instruction, we'll take it up.
My lord, add to my lord.
What about notice?
My lord, notice not receive any information, my lord. Regarding notice, not receive any information.
That also you get.
My lord, I will try my lord.
All right.
May I please, your lordship?
Yes.
Yeah, my lord, the FIR page, my lord, 12, my lord. Start from page 15. Page 15, my lord. The FIR, my lord. FIR. Here issue involved, my lord,
the petitioner, my lord, he was arrested on, my lord, 7/3/2006, my lord. And he was produced, my lord, on 9/3, my lord, after 24 hours. This point, my lord, I have given to judgment, and it is available in the file, my lord. And similar case, your lordship has also passed order, my lord.
Yes, anything to dispute this?
Lordship. Kindly forwarding report.
To the
forwarding report, Lordship.
yes.
Yes, 17.
70.
Yeah.
The victim was, the accused was arrested on 9/3/2026 at about 9 p.m. And information was received on 8/3/2026 at 1:40 a.m. And Lordship, kindly come to the notices under section 36, 47, 48. The date of arrest reflects, that is 9/3/2026 at 9 a.m. And thereafter, Lordship, the accused was produced before the CJM 9/3/2026 itself at about 3 p.m. 24 hours he has been produced before the.
Where is the seizure list?
Caesar list, Lordship, I have flag marked. That is also, Lordship, Caesar was made on
7/3.
8/3/2026 at around 1:40 a.m. in the morning hours, wee hour. I have flag marked in the case record, Lordship. Very simple, Lordship. Information was received on 7/3/2020 at about 10 p.m.
But thereafter, in your forwarding report, as if it appears everything happened on the same date.
Yes, Lordship.
7/3.
Nothing is stated that on the next day we went.
Lordship.
After that we received, after that we
Record
received,
speak,
after that
Lordship.
we received. That is-
He was arrested on 9th,
Page 16, my
at
lord.
about 9 a.m. And
By
Caesar
your
was
own, by your own document seizure list, that is
was
8/3/26. How can
made
you say it is
8/3,
9?
2026, Lordship.
Yes.
The record says at 1:40.
That means what? You seize the ganja and then let them go. Say that will come and arrest you later on.
Lordship, as per record says, Lordship.
Date is, my lord, overwritten, my lord. 8, my lord. And in the below, my lord, column 5, my lord, 7/3. And the FIR also, my lord, they went to spot on 7/3.
That is ZD numbers.
Lordship.
Column 5 is ZD.
And page 16, my lord, in the page 16, the FIR itself, my lord, that he was apprehended on 7/3 after completion of the same day.
Forwarding report says information was received on 7/3.
He was kept one day in
At
police
10.
station. Subsequently, he was soon arrested. Page 16, my lord, last two paragraph, my lord. After completion of all necessary formalities, the police party returned to police station along with seized articles and apprehended accused.
as per seizure list, even if overwritten date is 08
Yes, my lord.
03/26 at 1:40 AM.
1:40 AM.
So on the whole day of next morning, whole day 8/3/26, he was not produced. Right?
It was produced at 3 PM in the evening
Right.
on 9th.
That is what? So this 24-hour expired on the night of that night itself.
But so far as record says, Lordship, section and notices under section 36, 47, and 48. The date of arrest is reflected as 9/3/2026 at around 9 AM. Lordship.
Put any date there.
Submitting from the records, Lordship.
And we'll say that record days were manipulated. IO has tried to
Another issue,
manipulate the time of arrest.
That may be another issue. The court says, Lordship.
The IO is trying to take the court for a ride. The seizure list of the is of the date 8/3 and
Yes,
he
sir.
shows the arrest at 9/3. Trying to mislead the court to cover up his fault. Yes, we'll pass orders.
All right. May I please, your lordships? Lordships, in this matter, CD was called for. And
Lordship, that we have not received, Lordship.
I am behind the bar, lordships, for 33 days.
Anyway, it's the first date, so have a short date when you
Lordship.
say did not receive list again on.
Can be on 29th, Lordship.
23, either 23 or 24, lordships. Because 29,
8th, Lordship.
20, 29, it will be too long because 33 days is already been over.
33 days, Lordship.
Better your chances.
Lordship, 24?
Up to you. As a lawyer, you should be up to you to decide the date. What would be more beneficial for you?
24, lordships.
Haven't you seen so many lawyers telling their clients to wait, and before it's just before 60 days, file the bail application,
No, sir, no.
get the order. Huh? Yes.
27 logo pare na? 27. 28 question. 28. Oh, 28.
28, Lordship.
Obliged. May I please, your lordship? My lord, charge-sheeted case, my lord.
Friday or day after
Is it received or not?
Can copy received, Lordship. I have to go through that.
There learned additional people is the matter on Friday. Friday is tomorrow.
After some time.
On Monday.
Monday, Lordship.
Monday, in order to enable learned additional people to go through the TCR.
I'm obliged.
Obliged, Lordship.
To a item.
May it please your lordship. Lordship, regular bail application. Allegation is of possession of NDPS product, namely, my lord, ganja, and the quantity alleged falls barely just under the intermediate quantity, my lord. The small quantity is up to 2 kg. The alleged quantity is 2 kg 60 grams, my lord, as portrayed by the prosecution. Lordship, I am primarily seeking bail on 3 grounds, my lord. Firstly, that, my lord, my arrest was illegal, being that after apprehension, I was produced after 2 days. Secondly, my lord, to the best of my understanding, my lord, limited understanding, my 48 notice to my relative has not yet been submitted till date, from what I believe, my lord, in accordance with the mandate of law. And thirdly, my lord, the investigation is already over and the rigors of 37 is not attracted in this instant case, and there are instances where he may be allowed to go on bail and face the trial, my lord. Lordship's attention, I would first like to draw to page number 21, my lord, which is the initial complaint of the DRI, my lord. In the initial complaint at page 21, they state that, my lord, at relevant page number 22, that, my lord, the accused petitioner was apprehended at the Lokopriya Gopinath Bordoloi International Airport at 23:10 hours on 12/4/26. My lord, page number 22, point number Roman 2. Page 22, point Roman 2, the fourth line, my lord, that he was apprehended at 23:10 hours on 12/4/26.
Yes.
Then, my lord, on page number 23, in the first paragraph, last line, that then and there only he was issued spot summons under the NDPS Act, and then and there he was escorted along with his baggage to DRI office in Gauhati. This happened on the night of 12 April 2026, my lord. Then, my lord, I would draw your lordship's attention to page number 29, my lord, which is my production order. This states that I have been produced on 14/4/26, my lord. 14/4/26. Now, my lord, coming to the document, that is, my lord, the inventory and the seizure list, that is at page number 32, my lord. Point number 3, page number 32. May I read, my lord?
Yes.
Place and date of seizure. Initially intercepted Sri Sanjay Dohani, that is the accused applicant before your lordship, from the arrival gate at terminal this Gauhati on 12/4/26 at about 23:45 hours. Earlier it was 23:10 hours. That is also their document. This is also their document only. Even if it is 23:45 also, and sees this product from him. Then, my lord.
Where is the time mentioned?
Lordship, the time mentioned at page number 32, point number 3, my lord. Place and date of seizure. Initially intercepted Sri Sanjay Dohani from the arrival gate of Terminal 1, this Gauhati on 12/4/26 at 23:45 hours. In the initial complaint, it was 23:10 hours, half an hour discrepancy. However, that is not so true, my lord. Then, my lord, coming to their document itself, that is the Panchnama, that is at page number 41. Third paragraph, lordship. Thereafter, the DRI officials waited at the arrival of flight number FDM24 at Gauhati Airport. Around 23:10 hours on this, DRI official introduced himself to the passengers at the exit gate. So all their documents state that I was apprehended and taken to the DRI office on the night of 12th of April, my lord. And, my lord, now coming to the arrest memo, my lord, at page number 50, my lord. So from 12th night, I am in the DRI office, but my arrest memo says that is hereby arrested at 1700 hours, that is evening 5 p.m. on 13/4/26.
This page?
This is at page number 50, my lord. Page number 50. This says that at 1700 hours on 13th, my lord, I have been apprehended. And, my lord, for lordship's convenience, as I'm taking lordship through the documents, my lord, at page number 52 is my notice under section 48. This does not bear the signature, that is the last page, 52, this does not bear the sign of any witness or any relative, only the accused signature is there. 48 accused is irrelevant, my lord. And on top it is written in bold, informed through cellular calling. Informed through cellular calling, and later on, my lord, yesterday the objection that they have filed, they've stated that they've informed through cellular calling, they've sent messages over WhatsApp, and subsequently they sent it by speed post, but which has not been delivered because addressee was not there. So in my very limited understanding, till today, my lord, the 48 notice has not been served. Because cellular calling and WhatsApp, my lord, as per Mihir Ranjan Shah, lordship has meticulously summed it up in 2-3 judgments. I'll place them, my lord, before your lordship. So till date, 48 has not been complied with, in my limited understanding. And my lord, as per section 58 of the BNSS, I am to be produced before the court within 24 hours. And my lord, as per section 62 of the BNSS, any arrest and every arrest has to be made strictly in accordance with the Sanhita, my lord. So these are the violations. Apart from this, my lord, 2 kg 60 grams only, my lord, that they have alleged, my lord. Probably without the packages, that would be a matter of trial. It could be a small quantity even, my lord, though not admitting to the allegations. 95 days behind the bars, my lord. And as per their objection itself, they have submitted and my lord brought on record in paragraph 18 and 19 that on the night of 12th itself, I was in DRI custody, my lord. So my constructive custody and for all intent and purposes has started on the night of 12th. On 14th, I have been produced. They've said that they required the entire day for taking samples, making seizures, sealing and everything, my lord. So
I think your machine there showed less than 2 kgs.
My lord?
When you packed it, it showed less than 2 kgs, I think. Your machine.
That also, if we go there, my lord, under 2 kg also, their statement is that, my lord, one gentleman named Pratyush had handed me over the package and was given 10,000 rupees because he was overweight and I took it, my lord. And my lord, primarily on the, my lord, period of detention as well as the, my lord, illegality of arrest. If your lordship pleases, my lord, I would just place the judgments, my lord. Sandeep Sharma, Niranjan Singh, and I'm not placing right now because all those judgments in these 3 judgments by your lordship, these Supreme Court judgments have been meticulously discussed in details, my lord.
The charge sheet has been filed.
Charge sheet has been filed, my lord, awaiting framing of charge, my lord, to the best of my instruction. Lordship, this is an identical matter, my lord. Umanuddin passed by this honorable court, my lord, at paragraph 7 and 8, my lord. May I read paragraph 7, my lord?
Yes.
Paragraph 7, as already discussed here about the contents of the CD, it is evident that the petitioner was in effective custody of the police since 7:20 a.m. on 17/4/25 and the period of 24 hours would expire at 7:20 a.m. on 18/4/25 and even allowing a period of 2 hours of transportation, which is on the higher side from Jalalpur, Khandigram on NH 37 to the court of CJM at Sribhumi, the permissible period of production to the nearest magistrate would expire at 9:20 a.m. on 18/4/25. However, admittedly, the petitioner was produced before the learned additional CJM Sribhumi at 3:40 p.m. on 18/4/25. As held by the Apex Court Director for Enforcement, this is the Subhashina Sharma judgment, the arrest stood vitiated on completion of 24 hours of custody without being produced before the nearest magistrate, and that once a court dealing with a bail application finds that the fundamental right of the accused under Article 21 or 22 of the Constitution of India has been violated, it is the duty of the court dealing with the bail application to release the accused on bail. Here, my lord, the discrepancy was of 6 hours. Mine is more than 1 day, my lord, because 11:10 on 12th, then 11:10 on the night of 13th, my lord, the 24-hour expires. Another 1 date, my lord, 14th evening I was produced, my lord, as per records, as per their documents. Same, my lord, identical issue lordship has again dealt with, my lord, in the next judgment, Navish, my lord. Paragraph 4, 6 and 9, my lord. 4 and 6, my lord, reflect the time, my lord. Lordship had discussed that when the actual custody had started and when he were actually shown arrested. Here it was, my lord, on 13 to 26 at 11:20 p.m. However, seizure was recorded at 2:30 a.m. and is subsequently produced before the magistrate only on 15th. This squarely covers the present case, my lord. 15 at 1 p.m., which the forwarding report shows the time on 14 to 26 at 8 p.m., my lord. Lordship's observation is at page number 9, my lord, which is similar to the previous judgment, my lord. In light of, my lord, the Subhash Sharma judgment. Third, my lord, I shall not go into the details, my lord. This is the Niranjan Singh judgment of the Honorable Apex Court, where paragraph 7 clearly states that when is a person in custody within the meaning of section 439 CRPC, presently 483, my lord, that when he is in duress, either because he is held by the investigating agency or other police agency or allied authority, or is under the control of the court, having been remanded by judicial order or having offered himself to the court's jurisdiction and submitted to its orders by physical presence, my lord. No lexical dexterity or precedential profusion is needed to come to the realistic conclusion that he who is under the control of the court or is in the physical custody of an officer with coercive power is in custody for the purpose of section 439. And then, my lord, coming to the other two judgments, my lord, here this is with regard to the 48th notice, my lord. Lordship had categorically held in the Rashid Haq judgment, bail application number 3157, at paragraph 12 and 18, my lord, as to how and when, my lord, the 48 notice is deemed to be served. The onus is upon the prosecuting agency, my lord, to show that it has already been served. Why they have failed to serve, that is a different issue, and in language that is understood by them. And my lord, as per Mihir Ranjan Shah, which lordship had discussed in the other judgment, my lord, that is the Dhan Kumar Deka matter. Here, my lord, this is not lordship judgment, but this is of a coordinate bench, that, my lord, the only way permissible is, my lord, is in written, my lord. WhatsApp and telephonic calling does not qualify under Vihan, as well as, my lord, Mihir Ranjan Shah. And also, my lord, the rigors of 37 is not attracted. And considering the period and, my lord, the illegality of the arrest, lordship may permit with any conditions, my lord, to allow me to go on bail.
Yes.
Lordship, we file our objection, probably that is not on the record, in spite of calling by your lordship. And then lordship.
Anyway, you know the
No,
points.
lordship, the first round of my learned friend is that we produced before beyond 24 hours, 48 hours. Lordship,
24.
that is not correct. Lordship, I please to see the
Not 48, 24.
24 hours. Yes, he was intercepted on in 12, but lordship, he was arrested. Lordship, may please to come to the arrest moment.
Yes.
There is, it is already flagged, but lordship, in bail application, it is page 50. Married lords. First line, Sri Sanjay Dohani, son of so-and-so, is hereby arrested by me on 17th hours on 13/4/2026 under section 42 of NDPS Act on the reasonable belief that he has been violated the provision of section 8C of NDPS Act and thereby committed an offense punishable under section 20B, 2B, 23.
No, just answer this. You did not go through the entire notice. You say that he was arrested at 1700 hours on 13/4/26.
And he was produced before the learned magistrate.
And from the time 12:10 or
14. 13.
11 p.m.
Yes.
On 12th.
23:10 hours or 23:45 hours on 12/4/26.
He was not formally arrested on that day, Lord.
Yes, but was he free to go?
Lordship,
Could he have walked out?
no, Lordship, this is not submission, Lordship.
No, this is our question.
No,
You have to reply.
19 to
In paragraph 19 of our objection, I'll give my copy to your lordship. The statement made in paragraph 14 of the bail application are denied. It is submitted that the petitioner was intercepted at about 23:44 hours on 12/4/2026 on the basis of specific intelligence and was thereafter served with court summons under provision of section NDPS Act 1985. Pursuant thereto, he was escorted to the office of the Director of Revenue Intelligence, Gauhati for detailed-
Escorted,
Yes, Lord.
escorted like an accused or escorted like us,
Lordship,
escort vehicle.
If it was stated that only escorted to the office of the DRI.
Yes.
Then for detailed examination of his baggage, verification of travel documents and completion of proceedings contemplated under NDPS Act. The petitioner voluntarily accompanied the officers and all proceedings were conducted in the presence of independent witness and gazetted officer. The time consumed between interceptor and arrest was utilized for compliance with statutory safeguard, examination of baggage and recovery of proceedings, weighment of the recovered substance, drawal of the representative samples, field testing, recording of statement, preparation of panchnama, seizure memo, arrested details, arrested related documents and other mandatory legal formalities. Such investigation and proceeding steps undertaken in accordance with the law cannot be equated with the arrest or illegal detention. The petitioner was formally arrested only at about 17 hours on 13.
Okay, formally arrested at 17 hours, we understand, but from what you are reading, can you answer the straight question whether he was in effective custody or not? You have to answer, Niranjan.
Lordship there, but this point is still pending before the Honorable Supreme Court, whether from which time he will be.
Till it is decided, we have to go by Niranjan.
Lordship, here we have given explanation, Lordship, for consideration of your Lordship.
In other words, you are leaving it to the court.
Lordship. Our explanation is there in paragraph 19. Why he was intercepted on 12 and he was formally arrested on 13 for 17 hours. Regarding 58 notice, Lordship, may please to see that his page 52. What is so-and-so mobile number?
You have to wait till 5 PM to make the formal arrest. Why don't you make the formal arrest?
Because Lordship,
before
we have to
earlier and just produce him before the court.
No, Lordship, because we have to perform some legal.
All right, what you completed it by 5 PM. Completed it by 5 PM, then why didn't you produce him knowing very well?
Lordship, explanation is there in the.
You could have produced him on that day itself.
Which date?
On
He
that
was
14.
arrested- He was arrested on 12.
All right, you are saying formally arrested on 13/4 at
Yes.
5 PM.
Yes, Lord.
So even then you could have produced him.
Lordship, on next date within 24
No.
hours, he was produced before the learned magistrate.
Know the law, you. The lapses of your officers, don't try to unduly defend them.
No, Lordship, here because we have given explanation, Lordship.
Either you say either they are ignorant or they are callous. No, it can be only two things.
No, Lordship, the explanation is there. Now it up to your Lordship, may Lordship explanation given by the petitioner.
That is, we have already said what we think of your explanation.
So that is there, Lordship, Lordship may pass necessary order. We have nothing to. Regarding 48, Lordship. Wife was informed by our telephone and that is upheld by this honorable court by division bench.
And there is a third option. We may even think it's deliberate. That's happening everywhere.
Lordship. Lordship.
It's delayed production.
Lordship, here.
Nobody is ignorant of the law.
Lordship, they are aware about the law, Lordship. That's why, Lordship, all these things were completed and he was produced before the law. Because Lordship knows that we have to complete the necessary legal formalities.
We don't know. We know what is said in the Constitution.
Because Lordship has to see the practical.
We can't amend the Constitution, can we?
Lordship, correct. But recently, Lordship, Delhi High Court, after considering all the judgments, I come to a conclusion that written count of arrest is not required to be served. Then is not knows about
What is not required to be served?
the ground of arrest, Lordship.
That is a completely different issue. We are on the time of production.
No, Lordship, it is tough to consider well.
All right,
practical-
come to 48. Yes, what is, you were on 48. What is your explanation?
48, it has been served through cellular phone initially and it was posted through registered post. Lordship, interestingly, the wife of the petitioner approached initially learned session judge and thereafter this application was also filed by the wife. So if she is that she was not aware, Lordship, cannot be believed, Lord. She was informed and Lordship submitting on judgment of division bench, Lordship, in this regard.
When, what application was filed by the wife?
Mail application, Lordship.
When?
This application, Lord Court ticket also. Submit this application, may please to see this application, affidavit part. Page 20.
Page 20 of?
Mail application.
Yes.
Kalpana Dohani. I am the wife of the accused petitioner. It was filed in the month of May.
This is the present application. You are saying some application was filed before
it is the
session.
land trial court also. That must be in the record. Yes, Lordship, as per my instructions, she filed a bail application before the learned session judge also.
Question is when? If she files it after 7 days, 10 days, then that doesn't, then anyway she will come to know.
Lordship, because she was informed over telephone also on the various, and Lordship, WhatsApp message was also given to her. But we have flag mark that. In the record, we have flag mark that portion. Page.
But I think in Satinder, until it said WhatsApp is not good enough.
But our High Court says that Lordship division bench, I given judgment of the paragraph 22 of Hari's judgment law.
So I personally see no reason why WhatsApp should not be good enough if the copy of the notice is posted in this.
It was also posted and she was also given.
No, if the scanned copy of the notice is sent by WhatsApp.
Yes, Lord.
What is not good about it can be seen. Read grounds can be communicated that way also in this age and time. But I don't know, there may be conflicting decisions.
Our High Court in many judgments has said that communication through WhatsApp message, it is a proper service of notice on the petitioner. And the number was provided by the accused himself. Lordship. That has been written in the section 48 notice also. That part.
Provided that the grounds of arrest are available in that notice.
It is Lordship, may please to see the notice. Page 50. Page 50, 52. Ground of arrest is also there.
Now, how have you shown that it was sent by WhatsApp?
Also, may please to see page.
Any screenshot is there?
54. It is written in the notice also that informed through cellular calling.
Copy.
And we have also given the copy that is available in the LCR notes. Page 84. Lord. Is
84 of what? 84 of?
Lordship lower court record. Has been flagged mark. Lord.
What is this photograph of this man?
Lordship.
84.
No, Lord. It is in flagged mark. Lord.
Another set.
Left side, there is a signature of accused as well as the signature of witnesses.
User and witnesses is different thing. These are not family members.
Even on 13 itself, Lords.
Yes, sir. Like market as well.
Then Lordship, judgment of this honorable court in division paragraph 22, Lords. Reached judgment.
कोडिफाई की बात है. Yes.
Paragraph 22 of
Which one?
WBC criminal 50 of 2025. Lords. Married Lords. Paragraph
This one, Muhammad Farish.
Yes, Lord.
Yes.
Paragraph 22. Thus, not only the memorandum of arrest dated 29/10/23 was served on the petitioner with a reasonable time of his arrest of the petitioner, but on the same day, that is on 29/10/23 at about 8:45 p.m., the petitioner was allowed to intimate his wife, namely Yasmin, over her mobile phone number so and so about his arrest, which is due compliance of provision of section 50A of CRPC. Therefore, the ratio laid down in case of Kesar Reddy, Upendra Reddy, and Pankaj Bansal and Pal Kishore Supra cited by the learned counsel for the petitioner has not been found to be violated. If produce the screenshot of the notice before a lordship.
There is no, in this case, this was a WhatsApp.
We have sent, in this case, lordship.
It says notice was served with notice. It doesn't say WhatsApp.
It is, he was intimated over telephone lords, or his mobile phone lords.
It says over cellular calling, my lord.
It says para 23's petitioner has also been served with a notice.
Yes, in this case.
That is 50. Okay, that is different. 50 is different. It's not.
It is 47, my lord.
Yes.
There I have no dispute.
There it was section 58. Into section 48 of PNSS. This case over telephone, it was intimated in the case of Harish. But yes, in the present case, as well as he was intimated over telephone, and WhatsApp message was also sent to the petitioner. As well as the same was sent to by speed post also. Tracking is also there. Page 48 is the taking report loads. Was delivered on 29/4/2026.
Page?
Page, it starts from page 87. The LCR loads.
Page?
Page 88.
Page 8?
Already flag mark is there. Like probably in second bunch.
What is what is that?
It is lordship tracking report of the postal department.
Tracking report. What is it?
It has been flag marked and it has been written over the flag mark also.
Yes, next.
And before that, lordship, the envelope is also given by us, which said that the address is given to Sri Kalpana Dohani. And it was, as per the tracking report, it was delivered on 29/4/2026. Thereafter, she approached before the Rana trial court and after application has been filed.
The 29 is too long. That is.
Yes. Lordship, this is the tracking report. It was sent on booked on 13/4. Booked on 17/4.
That is after his remand.
And lordship, on the very same day, she was informed over telephone by her husband also.
Inform. You are to inform. Not he. You are to inform.
Yes, lordship, because lordship, the number was provided by her husband, lordship. And on same day, it was intimated to her over telephone, lordship.
What was intimated about his arrest?
Yes, lordship.
Yes, but
Yes,
that is not
definitely.
enough. The grounds of arrest are to be communicated.
It was communicated through by WhatsApp message, lordship. That is sufficient
But
compliance.
you
as per my
don't say
submission.
so. You just said intimated by cellular.
Yes, Lord.
Intimated what?
Yes, the statement, the lordship page 52 is there.
Only says intimated.
Lordship, entire notice is there that was posted on the same day. And I've given.
Posted on 17th is what he said, right?
It was posted on 17/4, but it was through WhatsApp or through WhatsApp message on 13/4 itself.
But there's no mention of WhatsApp here, my lord. In the notice, it's their notice itself, my lord. Sent by WhatsApp. Notice says informed through cellular calling.
Informed through cellular calling, lordship.
Does not say to inform through WhatsApp. Even though WhatsApp is not permissible, just pointing it out, my lord. I apologize.
You were referring to some decision which said that WhatsApp message is information is permissible, but this DB judgment that is
Lordship,
that
in
is
Paris,
telephonic information.
In lordship, on the same day, she was informed by her husband also. What's my place to see? Last line, the above information is conveyed to you under provision of section 48(1) of the BNS Act. It may also be noted that Sri Sanjay Dohani, Executive Person, has disclosed, mentioned you as the person to whom above information may be conveyed.
Yes, all right. Next.
Regarding lordship, it is correct, lordship, recovered quantity is below commercial quantity. More than lordship, we have already submitted charge sheet. So will take its own course, lordship. That cannot be a ground to release a person who is involved in trafficking of the contraband, lordship. Not only injuries to health of the public, but it also affects the society also. So considering this, lordship, not entitled to bail at this stage, lordship.
If an objection from I log edible. This is yours.
My lord, this was my copy, my lordship's perusal. Only one thing, my lord, just under a minute, if lordship permits, just one line.
Yes.
Just one line, my lord, to his reply, my lord. My lord, to what I have construed, my lord, from esteemed senior counsel's submission, my lord, that they are admitting, my lord, that the production was done with a gap of intermediate 1 day, my lord. That is 12th, I was apprehended, kept in their office. I was not a free citizen until I was formally arrested. My movements were under their duration control, my lord, and I was produced after about 40 hours, my lord, that 2 days, my lord. That has not been, my lord, satisfactorily addressed in accordance with law. And secondly, my lord, whatever they've submitted with regard to 48, even though that is the alternative limb of my argument, one judgment I have submitted, lordship's pronouncement, my lord, that is bail application 2720/2025, wherein paragraph 14, your lordship has observed, and I'm quoting, further, admittedly, the notice under section 48 BNSS was stated to have been served upon the family member of the petitioner by WhatsApp, which is impermissible in view of the directions of the Honorable Supreme Court in Satyendra Kumar until. The other notice under section 48 BNSS was served to one other person, Moinul Islam, as per notice of the case there. The petitioner identified him as his colleague and family friend. The issue of two different persons, but with regard to WhatsApp and cellular calling, my lord, lordship judgment as on today holds good, my lord.
Yes.
With regard to your lordship's queries about why whether he was a free citizen or not, that is replies in paragraph 8 of my final complaint. It may be
Even voluntarily, that
Yeah.
part.
No, lordship, here some more statement is there.
Para?
Paragraph 8
Of your objection,
of my final complaint.
final complaint.
Lordship.
It's for delivery of orders on Tuesday.
Good.
Be obliged.
Sure.
May I please, lordship, my lord? In this case, my lord, the petitioners are behind the bars, my lord, since 44 days, my lord. And kindly turn to page 9 is the affair, my lord. One line affair, my lord, kindly. Allegation is that, my lord, I kidnapped the victim and demanded money.
Did you received?
Did you receive, my lord?
Kindly see, my lord. On 14, the affair was lost, my lord, and the alleged occurrence, my lord, on 11, my lord. So on 11, my lord, actual fact is that, my lord, the victim, my lord, is my friend, my lord, and there is monetary transaction, my lord. And some altercation took place, my lord. He was in my house, my lord. He was recovered from my house. And on 11, my lord, the date of occurrence, my lord. And thereafter, my lord, 14, my lord, the affair was lost.
Yes.
My lord, in his 183 statement, my lord, it was categorically stated, my lord, how he kidnapped and restrained her in his house, and thereafter, my lord, demanded money, my lord.
That he had to repay me rupees 2 lakhs. I have stated in my petition also, my lord.
Initially 7 lakhs demanded, thereafter 3 lakhs demanded, my lord.
Yes.
My lord, in its 180 statement also same thing explained, my lord.
My lord, he will definitely, my lord, LS, my lord, because, my lord, kindly turn to page 3 of my petition, my lord, para 5, I have categorically stated, my lord, he has to repay 2 lakhs rupees to me, my lord, but he did not pay. So something happened, my lord, on 11, my lord, he was, my lord, restrained, my lord, in my house. It is admitted fact, my lord, due to my lord, some, because I got sentimental, my lord, but on 11 itself, my lord, he was released, my lord, to his parents, my lord. And on 14, my lord, the affair was lost, my lord. No kidnapping, my lord, because some transaction is monetary transaction is there, my lord. How, my lord, I can kidnap, my lord, a person, my lord, because I am not a habitual offender also, my lord. He is just my friend, my lord.
Only for non-payment of the, my lord,
Yes, my
money,
lord.
he was confined in his house, my lord, and also threatening and detained him in different unknown places, my lord.
And why then, my lord, immediately he did not lose the affair, my lord.
And
On
deadly
14, my lord,
weapons, my
after
lord.
3 days of the 4 days of the incident, my lord, he lost the
Demanded
affair.
7 lakhs thereafter.
Not, my lord, by him, my lord, by other person, other friend, my lord, of the victim, my lord, affair was lost, my lord. Not by the victim
No, my lord.
himself, because
Presentation.
he was released on 11 itself, my lord, and affair was lost on 14, but by his another friend, my lord, not by the victim himself, my lord. And he is recovered, my lord, and 44 days in custody, my lord. If charge sheet is filed, my lord, I will face the trial, my lord. And I was arrested on 2/6. After, my lord, 2 months, almost 1.5 months later of the affair, my lord. Preliminary, this is not a case of kidnapping, my lord.
We had learned counsel for the petition and learned additional 50. This is an application under and so. The allegation briefly stated against the present petitioner is that he is the victim, namely, what is his name?
Victim, my lord, Abdul Mohim Laskar.
Abdul Mohib Laskar,
Mohim Laskar,
who was known to him and find him in a house and demanded ransom from his family members. Ultimately, getting to know that police case has been lodged, the petitioner released the victim. Where it is submitted on behalf of the petitioner. The petitioner and the victim are known to each other and the petitioner had borrowed, victim had borrowed a certain sum of money from the petitioner, and it was only with a view to getting back the said money that the petitioner had confined,
Restrained, my lord.
Restrained the victim in his house and demanded the money. No case of abduction made out. But no case of abduction was there. That the FIR was lodged 2 days later after the release of the victim. which also points towards the fact that the story of abduction is a concocted one. Regard to the name as well as the period of detention of the petitioner is not necessary. Accordingly, the prayer for bail is allowed. 50,000 securities. Try to influence or intimidate the send back the CD.
Highly obligement, highly obliged. Wait, please, your lordship. I am in 55, lordship. FIR is at page 15. The gist of the FIR is that on 9/6, lordship, one Rekur Rahman was searched. 6.08 grams of heroin was
Yes, other than statement of co-accused, any other material
no,
is there?
lordship, that is what people say, lordship. Voting হলো, কি কয়, স্যার হদিস আপনার কাছে।
My lord, here one Rikibur was arrested, my lord. And from the statement of the my lord Rikibur, it was found that my lord, it was that he has purchased the my lord contrabands from Mufidul Hassan, my lord. That is petitioner number in the item number 56, my lord. And when it was, my lord, searched by the police, my lord, from his house, my lord, 40,970 rupees was recovered, my lord. And he also failed to explain any source of income, my lord. Source of how it is come to his house, my lord. And from the Rekibur, in his disclosure, stated that, my lord, he is purchased from the present that petitioner with 30,000 rupees, my lord.
Which one?
My lord, item number, my lord, 56, my lord.
From Resim Ali.
Mufidul Hassan.
Mufidul Hassan.
Mofidul Hassan, how much? 40,000.
40,970 rupees is from his possession, my
And
lord.
30,000?
No, he is purchased it from 30,000, my lord. A total 40,000 recovered from his, my lord.
What was from the other fellow, Resim Ali?
Or
Resim Ali.
Resim Ali, my lord, from the statement, it also reveals that, my lord, for Rekibur, he also purchased some contrabands from the present petitioner also. And here it was found that, my lord, against whom 4 cases are pending. All the, my lord, NDPS
No, this Resim Ali is the purchaser.
My lord.
Nothing in the as per the
From Rekibur,
My lord.
according to you. Why was he arrested?
My lord. Resim Ali, my lord, he, from whom was it was purchased by the one person, my lord? Rekibur, my lord. Ricky purchased it from the
Resim. Huh?
2 persons, my lord. One from the, my lord, Resim Ali, and one from the, my lord, petition one গৈছে that are petition,
One from Mufidul and one from this.
my lord.
Both are sellers,
My lord.
according to
My
the.
lord, according. And investigation is going on, my petition এখন গৈছে that. Both of
Recovery was made only from Rekibur.
my lord. And my lord, regarding my lord, in the statement, my lord, it was he has in Resim Ali, he was the habitual offender, my lord. Several cases are pending against him, my lord. And kindly peruse the CD, my lord. Here sufficient material is collected, my lord, and FSL report
It is not a commercial quantity, is it?
my lord. Here, my lord, it was although, my lord, intermediate, my lord, there's 27 A's there. There are 37 will come, my lord. It goes
Financing.
fine.
What is the allegation of financing here?
My lord, from the statement and during the investigation found that he was transporting contrabands from different places, my lord, and purchasing and selling in different area, my lord. It was in the IO note also there, my lord. And 30,000, although he purchased it from 30,000 and.
Is there any independent material that they are involved in transporting, financing, anything? Just saying his financing will not do.
From the statement, it reveals and or 40,970 was recovered from his possession, my lord. So it is purchased from 30,000, my lord. The amount of 40,970 was. And failed to explain the source of my lord death amount, my lord. And regarding the receipt, my lord, Lordship kindly bears in his forwarding also, my lord. Several cases are all of them NDPS cases, my lord, pending against him, my lord. And investigation is going on, my lord.
These are the statements of co-accused.
My lord.
Fact that he is dealing in drugs, that.
My lord.
Then ultimately it boils down to the same thing.
My lord, but my submission is that, my lord, it is investigation and to investigate the matter to find out the matter.
All
Yes,
cases
it-
where search sheet is
my
not
lord.
filed are in the investigation stage. So if that is a ground, then
My
we'll
lord,
call
for
for the
that
CD
purpose,
at
my
all.
lord, it is necessary to ask the accused person to where about he found it, my lord. Then it was linked, they are organized, my lord. Then one after one, it was found, my lord, their involvement, my lord.
How long will you take to ask? Statement was recorded on 10/6/26.
My lord.
How long are you going to ask him?
My lord, thereafter they were apprehended, my lord, on the basis of the statement of the, my lord.
Then from that also 1 month has passed.
My lord. Thereafter, my lord, and only one, my lord, FSL is yet to be received, my lord.
That has nothing to do with them. We are proceeding that it is drugs.
My lord, that is true, my lord.
May I submit, my lord?
Yes.
Except this statement of co-accused, which is not admissible at all. I am relying on two judgments, Lordship, one of our Honorable Gauhati High Court coordinate bench, one exactly in similar points, Lordship, of Himachal Pradesh High Court, where also 6.3 grams of heroin was recovered, 27A was also mentioned, and with detail that no, there is no sufficient material here. Co-accused statement is not admissible. In Honorable Gauhati High Court, in the case of Gogoi Deuri, Lordship, I have given, and being vast experience court, Lordship, Your Honor is also aware of that part, Lordship. Statement of co-accused neither under 67 after the judgment of Tufan Singh, not admissible. And then against me, Resimali, I was arrested after 20 days. Only basis on that, some old cases are there. Cases are of 23, Lordship. One I have admitted, given specifically in my para 5 of my petition, Lordship. I was a drug addict in the year 2023. Thereafter, one FIR, Lordship, I have copy of this 24 FIR here. They have mentioned 218/24, Lordship. 21B. I have the copy of the FIR in same case, Lordship also. It was recovered from one Khalilur, and basing on his statement, I was implicated, Resimali. Because I worked for a particular period as a informer to the police. When I refused, they started me implicating. This is the FIR of 218, Lordship.
Is that he is the habitual, my lord?
No,
Other
Lordship.
cases,
He was
my lord.
implicated there.
Implicated,
One I was
my lord.
drug
That's why
addict. I have
implicated, my
admitted.
lord.
23.
That's why implicated, my lord.
23,
They are
Lordship. That
organized,
was
my lord.
3 years. I have left all these things.
One after another, my lord, they are.
What is one after another? 23,
This is
Lordship.
my-
That is a 24
against him, my
FIR.
lord.
One Khalilur, 10 grams of heroin was recovered. I was nowhere in the FIR. But subsequently charge sheeted my name was implicated. I'm
Not-
facing the trial.
Not necessarily in the FIR, my lord. During the investigation, their names will come out, my lord. And I was
Established.
collected materials, my lord.
And in this case, according my forwarding report, I have mentioned here, page 18, Lordship. Simply basing on statement, nothing else, Lordship. Neither money was recovered from me, no drug was recovered from me. I am living a simple life, Lordship.
Investigation, publication against me to open.
And এইবিলাক তো একোই নাই যিবিলাক তেওঁলোক কৈছে ট্ৰাফিকিং লাগে 27 এর কথাটো কৈছে হারবারিং এন্ড ফাইন্যান্সিং নাথিং previous cases or there I have admitted that part. Because I was a police informer, I refused to work. They started me implicating in cases, Lordship.
It is their story, my lord, but CBI and other things, my lord. And
So, like
although
I am
they-
ready to cooperate with further investigation if
punching-
any, Lordship.
although to
And
punching-
as admitted by learned our additional people, Lordship, only case is pending for now FSL report, Lordship. No other material, single whisper, nothing.
even if the two punching not applicable, but for the sake of investigation, my lord, these are the organized crime, my lord. For that one after another, my lord. It is there from the.
This is a
information.
23 and 24.
And one information it was revealed, recovery was there, and others are also there, my lord. They are involved in similar cases for last several years, my lord.
I'm in 50, item number 56, my lord.
I have strong objection in this regard, my lord.
No problem.
No problem.
My lord, in this case, Lordship, I was arrested on 9/6/2026. Today is about 38 days, my lord. Against me, only allegation on the basis of the co-accused statement, my lord. Only recovery from my residential house, not from my possession, my lord. Residential house, 40,970. And we are living with my parents and in-laws, my lord. And from whom it was recovered, that is not described. My lord, 40,000 rupees. And then nothing, no contraband, my lord. And against me, my lord, there is no allegation like other accused, my lord. No antecedent is there, my lord, against me, my lord. And it is under 21B, a recovery from Reiki board. So, my lord, here in this case, though 27A is there, 37 is not applicable, my lord. The rigors of 37 is not applicable at all, man. With any stringent condition.
7A, my lord.
And that is regarding commercial quantity, man.
No, my lord.
We have submitted the, judgments, my lord. Objections are gone. That is regarding
for financing and
harboring, my lord. So we need not to explain these things to your
My lord,
lordship.
here lordship may kindly peruse 37B, my lord. No person accused of an offence punishable for offences under section 19 or section 27 or section 27A. And is there, my lord. And also for offences involving commercial quantity.
Commercial quantity.
End আছে মাজত।
Commercial.
End আছে তো, end হলে commercial হ'ব লাগিব লগতে।
Commercial.
And
If
commercial
commercial-
or section 27A.
No, nothing
And
written
is
from our
different part.
position. And in regards to
Will be released on bail on its
Learned
own bond.
Council, lordship, though recovery.
Put anything, Lordship, in the registration. They have got the power to register a case. In the FIR also, nothing is there. In my accused forwarding, nothing is there, Lordship.
But though allegation is that in several cases he is arrested, but not yet established against him.
Sufficient methods are there.
Thank you.
My lord.
Lordship.
Problem. Sufficient.
Sufficient method.
Not yet established, no trial is going on. Nine.
But senior is another court.
You fixed it at 2.
They were not present earlier, lordship.
Yes, next item.
Please, sir, lordship, I'm on interim, my lord. Case diary has been called for my.
Okay, then action. Deadline 31st of November.
Did not receive, my lord. They are interim.
Informant is here, my lord.
Informant is present, CD not received. Is taken on interim to continue to next
Continue.
date of list.
31st. Of last month.
May I please, Your Lordship? Lordship, I am on interim, Lordship.
29.
Received.
Here, charge sheet submitted.
You're allowed to go.
Huh?
You're allowed to, Lordship, may I extend the interim day?
For what? Either you appear there or
My lord. And then fight charge sheet number 31 of 26, dated 23/5/26.
I think we will have to see this TCR. I think we'll have to see the TCR. And so call for the scanned copy of TCR with the interim order passed earlier to continue the next date.
Yes, we shall also kindly adjourn this to the next day. Kindly adjourn this to the next day.
Well, in this case, already search sheet submitted, Mel.
21.
And against petitioner also search sheet submitted, Mel. After the obtaining interim protection, he appeared before that.
Stated that charge sheet has been submitted by CS number so and so. The prayer of learned counsel is the matter again on Tuesday did interim order.
Lordship, I'm being led by senior counsel Mr. Kane Chaudhary. He's on legs before court number 7. Lordship, after some time. Much.
352. May it please, Your Lord. Lord, Your Lordship, before I make a submission, Your Lordship will go through the order dated 1911-2016. 1911, my lord.
Order?
My lord.
Yes, what do you want?
My lord, the question here is whether the maintenance is from the date of order or it is from the date of application. That is the subject matter. And it has been heard. And the order was passed on 1911-2025, my lord, by Justice Honorable Sekia, my lord. And they have admitted that they will pay the amount. Now they have come with an affidavit saying that no, it is not applicable. That is the issue. 1911-2000.
1911.
1911. By Honorable Justice Sekia.
But what was said in the order of actually?
My lord?
The order of maintenance.
Yes.
Wasn't
It was
the
given
period fixed?
It was given from the date of order. But as per the apex code, it should be the date of
So
application.
that order you have challenged.
Yes. That it should be in the application. That is I have challenged before here. Because he was paying the interim maintenance. So interim maintenance was given to the 15,000. 10,000 he has been paid. Thereafter, my lord, I have given the calculation therein. The arrear amount has to be paid from the date of application. Since it is from the date of application by the apex code. That is the issue only. Whether it will be from the date of application or it is from the date of order.
Yes.
That is the issue.
That is the only issue here, whether it will be from the date of award or from the date of application, Lordship. My learned friend is relying upon Lordship Rajneesh versus Neha, Lordship. Lordship, that judgment was passed.
No, before we go to that, what do you say to order dated 19/11/25?
Lordship, this one.
Your concession is there.
Lordship, yes. Lordship, at that point of time, a different set of counsels were appearing.
No, that doesn't matter.
Lordship, yes. Lordship will kindly. The
This is a court of record. We'll presume it is true.
True. Lordship will kindly consider the respondent has filed a complaint before the Bar Council subsequently, Lordship, stating that Lordship, when he was called by his advocate, he was asked to sign on blank vakalat. This person who had appeared on that day was never engaged by him. And this was never his instructions because he was never engaged by him to appear for the respondent. To that effect, Lordship, he has filed a complaint before the Bar Council. Now, Lordship, what subsequently comes out in that is a different aspect. But that is his stand as regards the order dated 19/11/2025 is concerned.
Without engagement, he appeared.
That is the complaint. If your Lordship directs, I can file an additional affidavit, bring that on record, the complaint filed by him.
Let the concerned advocate be party or to that. Let Mr. Mazumdar be party to that because he has time and again before the court appeared and he said that I am being authorized to say so.
No, well, it depends on whether his vakalatnama is there.
Yes, there's a vakalatnama. Must be there. His name was reflected in the cause list, my lord. His name was reflected in the cause list.
Oh, only one respondent is there.
Yes, sir.
What is the date of this order?
19/11/2025.
19/11. 19/11/26.
25, Lordship.
So this vakalatnama is there 24 February 25.
Lordship, yes.
And how can
Dipjyoti Kolita. Pranab Kumar Mojumdar.
yes?
This filed this complaint stating that when he was called by his advocate, the concerned advocate at that point of time, he was asked to sign on a blank vakalatnama. This person was never engaged by him.
This is not a blank piece.
No, Lordship, the blank vakalatnama. I mean, Lordship, without entering that is his case. I understand 19/11/25 is a hurdle for me.
Why would anyone go to anybody and sign a paper?
The only aspect with regard to that.
You don't know that person. You don't know that advocate. Why would you go and just sign a paper? Vakalatnama. Is it believable?
The entire case is that.
What happened to the complaint?
Lordship, that has been submitted till now, Lordship. I haven't been informed of. It has been submitted, Lordship, around 15 days back, I am told. But till now, no instructions has come in that matter, Lordship.
The Bar Council is a different matter,
Lordship,
but we are going to go by our records. We did not necessarily agree with
Lordship,
that.
Lordship. The only issue with regard to the payment of maintenance amount, Lordship. What we
That is anyway the law.
Lordship, what we have stated is, Lordship, Rajneesh versus Neha, that was passed on the fact circumstance that there was a delay of 7-8 years in awarding the interim maintenance. In the instant case, interim maintenance was awarded right from the inception. The subsequent final maintenance, 25,000 amount, and Lordship, the Honorable Court has recorded reasons. Why?
It will be minus the maintenance already paid.
No, Lordship,
If
now.
any interim maintenance was being paid,
Lordship,
That will be deducted from the area.
Well, submission is that Lordship, Rajneesh, Honorable Apex Court nowhere curtailed the power of the learned trial court, the discretion to grant it from the date of the order. Lordship, in that regard, I am only relying upon a citation wherein Honorable Apex Court subsequently held that yes, discretion has not been curtailed, but there has to be reasons for doing so. Why
Yes,
it is
and
to
what
be
was the reason in this case?
Lordship will kindly peruse the order. Relevant part, Lordship.
Page?
Lordship, page 16 it starts, Lordship.
Page?
Page 16, Lordship, 16. The relevant part, Lordship. Or your Lordship can directly come to page 17, Lordship, paragraph 11. That will be more relevant.
Yes.
Here it, Lordship. Having considered the material on record, it appears that the first party is a practicing lawyer and is able to maintain herself without there being any support from her husband's second party. The first party in her petition in para number so-and-so has stated that she is competent to maintain her family because she is working in practicing lawyer in Gauhati High Court, but filed the petition seeking maintenance from the second party since he is the father and it is his legal duty to provide maintenance to the children. The second party, however, admitted that he is having a legal duty to provide maintenance to his children and accordingly provided fees for creche as well as school fees without there being any order passed by this court. He is an employee of Dr. B. Borwa Cancer Institute, Gauhati, and is getting a sum of around rupees 1,30,000, out of which he is getting a sum of 1 lakh as take-home pay per month. He is having some financial liabilities which can be inferred from the documents so submitted by him. He is taking a personal loan invest in Sukanya Samriddhi Yojana in favor of the children. He is also planning to take home loan so-and-so, and as such, considering the income liability of the second party together with the considering the fact that some more cases are pending between the parties, I am of the view that a sum of rupees 12,500 to each of the children per month would be appropriate and reasonable maintenance. In result, the petition by the first party is allowed on contest with a direction to the second party to pay so-and-so to the first party as maintenance. This is what is.
Nothing was said actually as regards the point of time.
No, Lordship. Paragraph 12, last line, Lordship. Lordship will kindly see to the first party as maintenance allowance from the date of this order. This is what the petitioner is aggrieved by. Last line, Lordship.
So what is the reason shown?
Reasons are recorded in paragraph 11, Lordship. As regards his financial liability and also the fact that he is investing amounts
No, that is
in favor of the children, Lordship.
Court has not assigned any reason specifically as to why the maintenance is to be paid from the date of the order and not from the date of the application. These are just narration of facts.
Aspect that he has been investing for the benefit of his daughter. Those have been recorded by the Honorable Court.
These are factors taken into consideration for arriving at the figure of 12,500 for each of the two children. How can he say that this is the factor that led him to pass this, allow this order from the date of order? No reason is there otherwise also.
For this, there is.
How many years?
Presently, I am told around 17 and 17 and 14, sir. 17 and 14.
The girl is 17, the boy is 14.
No, I'm not asking that. What is the date of the application?
That is in 2018, July 2018, if I'm not wrong.
So from 18 to 23.
June.
June 2018.
5 years.
5 years.
I have given the calculation in my petition, my lord. The lordship will find in paragraph 8 onwards, my lord. I have given the calculation. Is to pay the area of 6,75,000.
That is after deducting the 15th.
Because from if the date of application is taken, then he has to pay from the 6,75,000. Because his interim was paying there. He was paying the interim.
Paying the interim amount, Lordship, 15,000 interim amount.
10,000 he was paying out of 15,000.
So it's, if it is from the date of application, it would be 25,000.
Yes, 25,000.
So
So
another additional 10,000 as area he has to pay for this period
yes.
per month.
His dues is 6,75,000. He has to pay the area amount. Judgment which I placed, my lord, criminal appeal 2112 of 25, Shahjahan Bhatta, State of Uttar Pradesh. Your lordship will find in the paragraph 17 and 18. It has been made crystal clear. And it relied upon the Rajneesh and Neha case, my lord, by the apex court.
Relying upon the same judgment, paragraph 17.
Yes, we have relying on 17. The argument is that in this case, since interim maintenance was awarded and it was being paid, this ratio doesn't apply. That is your submission.
Right.
But what about the figure? It's not the same figure.
Lordship.
They're paying 15,000. Ultimately, court found it was they're entitled to 25,000.
28%.
So why would you not pay the arrears remaining shortfall?
Were taken into because back again to 2018.
Where is the paragraph regarding necessity of issuing reasons? Where is the paragraph regarding discretion of the court?
Lordship, paragraph 17, Lordship. Paragraph 17, your Lordship will kindly see. Fifth line, Lordship. Starts with of course.
Course 25. That same has to be justified. Basically, your submission is that whatever has been stated in paragraph 11 of the impugned order, all these factors apparently weighed in the mind of the court while deciding to grant maintenance from the date of the order. Yes.
My lord,
Raji, anything, any more?
yes,
submission?
only, my lord, only that point. So that apex position, my lord, Sajan, para 18 is also strictly clear, my lord. Para 18 of the judgment. No doubt that Rajnish was pronounced after the family court order and impugned order was passed, but in invocation of the law would entitle the maintenance would be recognized as award from the date of filing of the application in this behalf. Having regard to the totality of the facts in this account, we direct the respondent number 2 to pay 4,000 per maintenance to the appellant from the date of filing of the maintenance petition before the family court. Crystal clear, my lord.
Yes, that is all.
Only for a moment. Assuming Lordship it is payable from the date of application, page 26 of my affidavit, I have stated Lordship, around 3,24,700 has been paid. Assuming for a moment that it is to be payable from 2018 Lordship, out of that area, 3,24,700 has already been paid.
They have not paid, only 25,000, 10,000 they has to pay it, my lord. How can they say they have paid 3 lakhs?
Then
I have given the
my
calculation.
should have denied that Lordship at least. We have given the entire where we have paid on what amount we
But
have
if
paid.
he has expenditure for the children education somewhere else beyond 25,000, that is his prerogative.
Oh,
But the
Lordship,
judicial order is, my lord, 25,000 he has to pay.
Then that
That's
will-
all.
then that
What
will
he
be
has
very
spent,
difficult,
it is
Lordship.
his duty, my lord. But judicial order is 25,000.
I am not following. What 3 lakh is paid?
Lordship, towards his children's education, coaching fees, tuition fees, on all those counts, Lordship, around 3,24,000 has been paid, over and above the current final maintenance of 28,000, Lordship.
That we cannot decide.
No, Lordship, because your Lordship will see these are towards the children. Now, if this amount is over and above the amount payable, then that will be a big problem, Lordship, because this amount is towards the maintenance of the children. And these expenses have been incurred for the children, for their education. Now, if that is ousted, then probably my learned friend will also find very,
Who will
very
verify all that? You are supposed to pay 25,000 per month. There is a process by which you are to make that payment. If beyond that you have done something somewhere else, we can't go into all that.
Lordship, then
You can make so many claims that way.
children probably will suffer, Lordship, at the end of
No,
the
no,
day. That
no,
is the
suffer.
difficulty, Lordship. Because
He
these
will
were for
not
the
suffer.
children. Although if this is to be paid, the education expenses which he was bearing, which he was under the impression that it will be adjusted, that will have to be stopped then by him. He cannot.
The mother will take care of it.
Very well, then mother is well earning, Lordship.
Let him first comply with the judicial order first, my lord.
Mother,
Then no, then
Mother-
the matter will come.
You stop paying. She is happy with the 25,000. You stop paying, father. How can we go into all that, but you have paid? Suppose you are to pay 25,000, then out of love you give them a car worth 7 lakhs or whatever. Then come and say that I gave them a car.
Will kindly not,
Who asked you to give?
Lordship will not consider this the car, it's for their education. A class
We don't
12
know.
child.
That is what we are saying. We don't know what you have spent on.
Lordship, I have stated categorically
How
in my
you have
affidavit-
spent.
in my affidavit, Lordship.
Here. Not good enough. It should have been there.
No, Lordship, this is after they filed this, because earlier they have claimed 6,75,000. Thereafter, we have made these payments, Lordship.
Has he agreed to admitted that?
He has not denied it, is that not?
How can he deny it?
He has to file an
Because
affidavit in reply denying it.
Because it is his prerogative how he gives the expenditure to his children. So far the judicial order is concerned, he has to pay 25,000. From the area he has to pay.
This is not a continuation of the trial.
Yes.
And where is your right to file an affidavit? This is a criminal revision petition.
We have only brought those on record.
Yes.
Nothing more to.
He is not obliged to rebut whatever you have said. We are on the legality of the impugned order. That is all. You cannot bring in additional facts in a revision petition. Yes, CAV.
Right, Lordship.
Right, your lordship.
Please, your lordship. They are allowed to take steps upon respondent number 2, my lord. Informant, my lord.
As prayed for by learned counsel for the petitioner. Steps to be taken for service of notice on respondent number 2. List again. 4 weeks.
My lord, this is a criminal revision petition.
Hmm?
My lord, informant amicus curiae has been appointed on behalf of respondent number 2, my lord. Let the matter come on hearing, my lord. Early there is some urgency in this case, my lord.
To be listed for hearing.
Hearing, my lord. Because LCR has also LCR. I think LCR is there in
PCR receipt.
PCR. Sorry, PCR, my lord.
This item
Item 43, my lord.
3.
42 है 43 could. Counsel for the petitioner in addition. Have you served copy on the amicus?
Today she is absent, my lord. Today I bring the copy, my lord. Today she is absent, my lord. By tomorrow I'll give that copy, my lord.
L. Devi, learned amicus for respondent number 2 is not present today. TCR has been, scanned copy of TCR has been. Hence fix the matter for, is the matter for hearing on given date. Hearing order passed earlier to continue. Next date of finder and served the copy.
Yes, ma'am.
Yes.
They here in this matter, lordship, they have filed a IA lordship to vacate the impugn order, lordship.
State has filed this IA, my lord. Earlier in this case, my lord, interim order is there, my lord. Already, my lord, investigation has been stayed. My lord, although from the stay order, it reflects that, my lord.
What is the case?
Case, my lord, impugn order is at page 44 of the petition, my lord.
Yeah, my lord, in this IA lordship, we would like to file our affidavit in opposition, lordship. Because lordship, this IA is filed by IU lordship, and the affidavit, first thing is that the affidavit is swear by one.
All right, you
Dinesh
file.
lordship. We'll file our objection.
I would like to point out one aspect here, lordship. In this case, although interim order was passed on 21/26, my lord, but at that point, a TCR was not called for, my lord. Stay is already there, my lord. Probably TCR would be necessary, my lord.
First, lordship, this IA has to be disposed of, lordship. We'll file our affidavit in opposition, lordship.
But in the main petition, you write hard so and so learned counsel for the additional PP. What about respondent number 2? You did
We
you
have
take fresh steps?
taken step, lordship. Thereafter, your lordship direct us to take fresh step. We have already taken fresh step, lordship.
Submitted that petitioner has taken fresh steps for service of notice upon respondent, but per office note dated 14/5/26. ID card or unserved notice has not been received back. Fourteen 7/26 office note. 7/26. With service on respondent number 2. Interim order passed earlier is extended till the next date. In the meantime, call for the scanned copy of the TCR. IA.
PRC case number 358/22 pending in the Court of Learned Additional Chief.
Case number.
PRC case number 358/22 pending in the Court of Learned Additional CJM Tinsukia.
Yes. IA. Counsel appearing for the respondent prays for time to file objection to the present IA. Here is allowed. Is the matter again on?
Acknowledgement.
Yes, what is this?
So we had to come again in a application for review. And there are two ways of looking at it at present manner. Lordship may issue notice and fix a date for final disposal. And if they are agreeable, then
Who you are appearing for?
Respondent number 2, my lord, Somnath Chatterjee. 1 and 3, perhaps notices up to be issued, my lord.
and I'll be arguing only on the basis of the order passed by Lordship and no other documents will be necessary.
We are opposing the review application.
Mr. D. Majumdar, learned senior counsel.
On the
Who are you appearing for? UFO?
Respondent number 2, my lord.
Mr. Banerjee is there leading me. We are for respondent number 2.
2, okay, Mr. Banerjee appears for respondent number 2. Any other respondents?
There are 3 respondents altogether. So 2, if my learned friend has accepted notice, for 1 and 3, possibly notice will have to be.
Copies of the petition be served upon the learned counsels appearing for the aforesaid respondent. To notice to the remaining respondents. Steps within 3 days.
Affidavit.
Release the matter.
Dusty also may be permitted.
My lord, kindly give a leave to file an affidavit.
And my submission will be unnecessarily increasing volumes of papers may not be necessary. All these documents, necessary relevant documents, we have annexed. After hearing me, if your lordship desires some other document which are not at all relevant. In fact, all the documents I have annexed. This itself is a volume.
Lordship will kindly give me 2 weeks time to file affidavit, man. Mr. Banerjee.
We'll file a short affidavit, if anything is, and we'll take the point of maintainability.
So you want to file the affidavit for what purpose?
Other documents, if
Point of maintainability, for that you don't need to file an affidavit.
no, that we can argue. Yes, correct. Correct.
Yes.
Any documents which are not there, we'll put that on record.
In a review, what new document can come?
No, except what is there on record, nothing
I
else.
have annexed all the relevant
No,
documents.
all documents are not annexed.
Anyway, madam, if they want to desire some, if they desire to file some document which is not there, let them do it. There is no difficulty.
Leave granted to the respondents to bring on record any documents that may not be have been filed in the instant review petition. List again on 4 weeks.
Respondent number 1 and 3 will have to be served. After 3 weeks, let they be here.
Four weeks, sir.
4 weeks, any specific?
Yes, give a date.
12th August.
Can it be 11th? Doesn't matter. 11th, if it's possible.
No, 11th, I've got difficulty. That's one arbitration matter.
Then
I think on that date we'll only be awaiting service.
Let it be 10th, my lord. 10th is a Monday.
10th, very well. 10th, very well. 10th,
Will not be
10th,
that necessary.
10th.
Obliged.
I'm grateful.
We may be
I'm grateful.
Maybe permitted to take steps for Dusty.
Yes, Dusty also mentioned
Fine.
take steps, including by way of Dusty.
Fine.
Grateful, grateful.
Maybe your lordship. Lordship, on two occasions, we took the steps for serving the notice to the respondent number 2. But as per the office note, the notice has been returned back, answered with postal remark that address is left. But as per our instruction, the respondent number 2 is residing in the same address that is mentioned in the cost title.
Where is that, Gauhati?
Yes, lordship.
Why don't you serve by Dusty?
I pray before your lordship that the notice may be sent to the local police station.
Learned counsel for the petitioner. It is submitted that notice has been returned with the report that addressee has left the place, but as per instructions received, the respondent is still residing at the same address. The petitioner is permitted to serve notice through concerned police station by routing the same through the registry. List again on.
Applies your lordship.
State, my lord, has filed this, my lord, appeal against acquittal, my lord. The delay condonation, A is for delay condonation, my lord. Delay is 188 days.
In IA, we have already filed our affidavit in opposition today. Probably this is not available on record.
Not available.
Not available on record.
Submitted that the respondent has filed section, but the same is not available on record. Registry is directed to the matter along with the same section. Taken on.
Oblast.
Please, your lordship. There's an IA, my lord, for suspension of the sentence, my lord. The NDPS case, my lord, where, my lord, I have been sentenced, my lord, 10 years. 51, 7.
How many?
10 years, my lord. And the state has filed, my lord, their objection, my lord, with regard to the bail, my lord. The lordship takes up the matter today, my lord. It will some time will take some time, my lord, or
To do some other time.
Tuesday, my lord.
Prayer of learned counsel for the applicant, place the matter again on
Tuesday. The Tuesday will, I'll give you.
Okay, in item number 47, except 30th July, my lord, any other date may be fixed, my lord.
Yes, item 22, some instruction was supposed to be taken.
My lord. Yeah, I have received the information, my lord. Here's charge sheet submitted, my lord.
Lordship, I am behind the bar for 76 days as on today. Kindly page number 22, the arrest memo, your lordship. The arrest memo, your lordship. That is The investigation has not taken the signature of the relatives, witnesses, or witness of the accused person. Completely the violation of the law, Your Lordship. Page number 22. They ought to have taken the signature of the witnesses by relatives of the accused person, which they failed to take, Your Lordship. Another page number 25, I would to praise Your Lordship. I had prepared a bail application before the trial court, Your Lordship. There the informant has appeared and has filed a petition through the special PP saying that they do not have any objection regarding the bail of the accused petitioner. Considering this aspect, Your Lordship, I may be allowed, Your Lordship. Section 10 is there.
First of all, my lord, here search is submitted, my lord. Regarding the service report, my lord, we have also received the service report. Service completed, my lord.
Anyway, since we had called for the CD and CS has been submitted, we have to see the CS now. Scan copy. Who is served?
My lord, duly served, my lord. Informant to the informant, my lord, that is Qasim Das.
And an additional PP submits that the charge sheet has been submitted by CS number
101 of 2026, dated 16/6/2026.
Call for the scan copy of the TCR along with CD. It's further submitted that notice on respondent number 2 has been served through the concerned police station as per instructions received. One appears for the and so is served upon her newly appointed amicus. List again on
Apologies. Met with the Lordship. Lord, CD was called for, I see, second. Lord, basically, my lord, it's a ego fight, my lord. What had happened? Lord, actually, we filed our affair on 2nd of June 26, but it was registered on 8/6. And police acted on the, my lord, other side's affair. That is, Lordships will get it, page number 24. Hmm. 24, no? 24 to forwarding. Sorry. Page number 13, Miller. Please come to page 14.
Informant is Abdul Sattar Ahmed.
Yes. In fact, my lord, I am filing this petition on behalf of petitioner number 1. Accused number 1.
Abdul Motin.
Except accused number 2 and 6, my lord, they are already arrested. They are now in custody. Accused number 2 and 6 were arrested on 4/6/26. Now they are in custody. Yes. Now please come to page
So
14.
2 and 6 are arrested.
Arrested.
This is an AB.
It is an AP, my lord.
So you are for whom?
I am for the other accused
other.
persons. My lord, actually what had happened, actually this plot belongs to me, my lord. Actually, my lord, they came to, my lord, possess the shop premises over the land. In the, my lord, ensuing, my lord, there was scuffle. There was some, both sides, my lord, they resorted to some wrongdoing, my lord. Let us be very clear about it. And as a result, my lord, both sides suffered some minor injuries. And what they used was lathis and all.
Actually, my lord, I have annexed the sale deed also, by virtue of which I purchased the plot of land. Now, most respectfully, it is submitted that I had purchased a plot of land at Jonia Market. In front of my land, the shop of the accused number 1 is located, that is the petitioner. Accused number 1 had taken the shop on rent. He has been earning from the shop without paying rent to the shop owner since last 3 years. When the landowner asked to vacate the shop, but he denied. Further, he started erecting fencing wall with an intention to encroach upon the land purchased by me as well as the land of the owner. When the landowner obstructed, accused number 1 encroached upon the land, stating that he had purchased the said land on 2/6/26, was scheduled for making payment to the landowner. I went in my four-wheeler vehicle, so and so, carrying so and so. The above accused persons formed an unlawful assembly and questioned me why I purchased the said land and forcibly trespassed into my house armed with the deadly weapons such as machetes, daggers, spears, iron rod, axe, and brutally assaulted my father Lokman Ali with an intention to kill him, causing severe head injuries, fractured his right hand, and also caused grievous injury on his left hand. Doctors put on stitches on his head and hand, and his whole body was smeared with blood. When my mother, Kamala Khatun, came forward, she was also assaulted and fractured her right hand and caused grievous injuries on various parts of her body, and they also tore the clothes she was wearing and made her almost nude, thereby outraging her modesty. They also dragged my wife, Asma Khatun, from inside the house by holding her hair and thrashed her in the courtyard and brutally assaulted her and caused grievous injuries on her head, waist.
Any medical evidence is there?
We have received the medical injury report in respect of It's 187.
And I understand, my lord, the case diary in my case has also come. Correct? Yes.
But
My lord, basically, I purchased this. Sorry. I have annexed this sale deed also. It's not that I'm a tenant under anybody, my lord. Yes, there was a, my lord, show of arms, show of twists. This was there, my lord. Let us not, not that, my lord, it's a case where the lordships will refuse to exercise the discretion, my lord, considering the nature of the, my lord, allegations. The cross affair, my affair was earlier in point of time. It was never registered. It was registered on 8/6. My lord, will abide by any condition which your lordships would like to impose, my lord, and will cooperate, my lord. I don't think my custodial interrogation is necessary, my lord, having regard to the nature of the allegations and medical report and all. Civil dispute. At the end of the day, my lord, it's a civil dispute, my lord. Going by the first para of the FIR, it clearly reveals that it's a civil dispute, my lord. The accused number 1 had taken the shop on rent. He had been earning from the shop without paying rent. That means allegation is, I am not paying rent. When the landowner asked to vacate the shop, but he denied. So premise on which, my lord, the FIR is based, my lord, it is basically in the nature of a civil dispute. Of course, lordships will have a look at the case diary, my lord, but I don't think it's a case where lordships would like to decline to issue, exercise your lordship's discretion, my lord.
And dispute between two couple took place. 4 persons injured. They have sustained previous injuries as well as simple injury, lordship. And to that regard, lordship has asked for the medical report, injury report. And we have received the same, lordship, in respect of Borpeta PS case 187/26. And so far as Borpeta PS case 206/26, their case is there, that in that case, lordship, injury report we have not received. Yes, lordship. Lordship, both ways. Sustained simple injury as well as previous injury by blunt force impact and weapon as well as blunt weapon, lordship, both.
This is the injury report of petitioner number 5.
Sustained injuries, grievous injuries on the vital part of the body, that is on head, skull, forearms, The section 118 of subsection 2 of BNS is concerned, Lordship, is voluntarily causing previous hurt by dangerous weapons, Lordship.
Petitioner 5 or
Blunt weapon it says.
Blunt weapon as well as sharp weapon. But
Token card.
they have sustained grievous injury
Token card.
as well as simple injury.
Lokman Ali.
Yes, Lokman Ali is the
Also injured, my lord. Thrown ML. Record, I have also filed an application, my lord. Citizens, 2 senior. Bones broken, my lord. All progress, they are on our hands and.
Previous is in respect only of Lokman.
Lokman Ali, Lordship.
Otherwise, others are simple.
Simple injury. There's a mob attack, 60, 70 people gathered together, Lordship.
Not 60, 70.
For as the
Some
FIR
15.
is concerned, Lordship, 60,
15,
70
20.
people gathered, they have attacked.
And the photographs which
Obviously,
I
they
have
have
given, my lord,
vandalized
that is
the
the
entire
injury
thing.
report of petitioner number 5,
Uh,
4 and 5.
They have armed with lethal weapons, Lordship.
Not. It is not.
This, your dangerous weapon has caused blunt injury.
No,
Blunt, my lord.
Blunt weapon has caused the grievous injury.
Previous injury. Other ones,
Not blunt, down, my lord.
they have
down.
sustained head injury, Lordship, that is the vital.
No,
part
no,
of
we are going by your report.
the Lordship.
It says fracture, radius,
Also sustained skull, injury on skull, Lordship.
blunt weapon.
Because they have armed with, Lordship, iron rod, now lathis and all, Lordship. All are lethal weapons.
All that they have come.
4 persons injured, Lordship, out of them.
And what about their injury report?
That injury report we have not received, that is awaited.
My lord, that's the photograph which I have given, my lord, of the person is petitioner number 4, accused number 4, and the person who suffered injury, head injury is petitioner number 5. Accused number 5.
Statement of the eyewitnesses also, they have also implicated. They have also implicated the petitioners, the complicity of the petitioners of very much real materials on.
And that will go through.
Yes,
Go through that, but before that, we want to see the.
Other case diary.
Yes, why has the case diary come without the injury report? What is the point of that?
Have called for both the case diaries along with the injury reports, Lordship. But have received only one injury report.
It is helping them, it's not helping us.
Hmm?
It's
So
the
Lordship
efforts
may
also
give
later
us,
occur, might not, time and might not. Have refused to, start the affair also, because they have also come, and my client has purchased the, they have purchased the land, but register is zero. Landowner, he is ready to file a petition before this. Verifying certain things, my lord. I have, I am allowed to read the FIR again, my lord. That I have purchased a plot of land at Dalia Bazar, and there is a shop of accused number 1 in front of my land, which he has taken on rent. The accused number 1 is running his livelihood by the rented shop without paying any rent amount to his landlord for 3 years. Not 1 or 2 years, 3 years. On telling him to vacate the rented shop by the landlord, the accused number 1 felt annoyed. Moreover, the accused person number 1 and the
intend to grab the land by giving fencing around the land which I have purchased from the landlord. That while obstructed to do so by the landlord, the accused number one claimed that he has purchased the land and so he is taking possession of the said land. On dated so and so, I was supposed to pay the installment about of rupees 95,000 for the land I purchased from the landowner. That I carried the said amount in my own car, numbering so and so. That by saying why did I have purchased the land from the said landowner, the above mentioned accused persons carrying the cleaver, zong, rod, and sticks, etc., by forming an unlawful assembly, illegally entered my house and hit my father, Lokman Ali, on his head, causing severe cut and broke my father's right hand. Subsequently, doctor stitches the injured parts wherein the whole body of my father was bleeding. Thereafter, when my mother moves forward to save him, father, the accused person, also hit my mother and breaks her right hand. All bones broken, my lord, and the clothes being worn by her was also removed to near nakedness by affecting her woman dignity and outrage her modesty. That my wife Asma Khatun was dragged by her, holding her hair from inside of the house, and stripped. Whole family was tortured, stripped down on the floor on the courtyard, and was hit by sticks on her head, waist, and on various parts of her body, leaving her severely injured. That when attempting to rescue my father, mother, and wife, I was also hit by rod and severely injured by the accused person, and vandalized my above mentioned car and takes rupees 95,000 amount from my car, glove box, and snatch away a gold ornament of my wife and her from her neck. It is important to state that my child, aged about 1.5 years, while crying at the time of the incident of the accused number one, pushed my child with the intent to kill her. Actually thrown away, my lord, the language is that on saving our lives from the attack, the accused persons, after seeing the public gather in my house, ran away from my house. That there are many witnesses to the incident, and after seeing us in this difficulty, took us to the Barpata Medical College Hospital for the treatment. That for the ongoing treatment and mental disturbance, some delay is caused in filing of this FIR. So only these accused have come and they have attacked. There are 20 people. They have attacked the whole family like Gauhati. Gauhati also, my lord, they have snatched the money. And 1.5 year child was, my lord, thrown away. And he is also small baby, injured. So, my lord, it is not lesser than, my lord, that Nogao, Gauhati case, the wife was killed. Here, my lord, person has not died. Because the neighbors has come to their rescue. All neighbors gathered, then they went and left them. So it is, my lord, not a fit case for giving bail. The trial should be commenced and each and every accused should be examined, my lord, who have caused the injury. So I, my lord, humble request not to allow grant any bail of such kind of incident, because it is not a small incident. Vandalizing one's house, committing Gauhati, hitting, tried to kill them, my lord, by making severe injury. So it is not a simple case to grant bail, my lord. Or not by mistake, it's a plan, my lord.
Can you have the injury
It's a
report?
planned incident.
Another case.
The report has not come.
And can you have?
Milord, can I point out one thing, Milord? If your lordship kindly takes the petition, their FIR was lodged on 4/6. Kindly mark that, Milord. We filed our FIR on 3/6. And please come to page number, Milord, 39. Sorry, 40. Please come to page 40, Milord. My learned friend is complaining that police is on our side. Let us see police is on which side. Page 40, Milord. This is the FIR, Milord, in vernacular. Kindly see the GD entries dated 3/6/26. As a lordship notice that, Milord, on left hand side, in the middle,
Page 40.
40, my lord,
Yes.
is our FIR. Then now, my lord, will kindly come to page number 37.
My lord, 8/6/26.
Now they have shown that the information was received on 8/6. And now this, my lord, will prove who is working on whose side. Our FIR is of second, TD entries of third. The case is registered on 8. Their FIR is on 4 after our FIR. And they do not register.
Yes.
Then Milord will kindly come to Milord at page 34. When the police registered the case, what is the premise, Milord? Kindly come to page 34, towards the bottom of the page. Medical certificates enclosed. Then I have conducted inquiry into the matter. During the course of inquiry, prima facie evidence has been found indicating commission of cognizable offence. Therefore, I kindly request you to register a case under appropriate sections of law for completion of the investigation of it is in our case, our FIR.
Yes.
That's why I said, my lord, considering the
Hal and
nature of
Key.
the case.
That is, my lord, all.
One is Hal and one is
Family
Hal,
members-
one is Hingi.
Family members were, my lord, at house. They were attacking their house. I have not gone to their house, number one. Number two, everybody was in hospital. So, my lord, the affair was lost by their.
So, my lord, everybody is
on the letter.
It is in
But they
that
should serve
perspective,
it.
my lord,
We have
I
not-
made
we
that
have not
submission
come to their house.
initially.
The housebreaking is also an offense, my lord.
Let us have the injury report. Yeah. Yes, CDB retained, you call for the injury report. When? Monday?
Lordship, forfeit,
And that makes it.
can it be on 23rd, Lordship?
All right.
It had been.
Counsel for, senior counsel for the petition and learned edition LPP. Government PD of both the cases. That is Corporate PS 187 of 26 and 206 of 26 have been received, but however, in the latter case, the injury report is not available. Call for the injury report of Corporate PS case number 206 of 26. Place the matter again on 20.
I do, I'm right.
Yes, okay.
Acting counsel A.K. Gupta has some personal difficulty.
So you were supposed to obtain instructions only. It was stated you have no contact with the petitioner. List on Tuesday again on the prayer of. CD আছিলে আগৰ কেছটো কেছটোৰ CD আছিল
May it please, Mr. Lordship.
Lordship, this is an appeal against conviction. Against the offense of rape, Lordship. The punishment given is 10 years. And the appellant is in jail since 23, Lordship, almost 3 years. Here is here. Lordship, before starting, Lordship, I would like to just focus. Lordship, there was a delay in the FIR, Lordship. The occurrence happened on 16/3/13, but the FIR was lodged on in 23/13. And that delay is not explained.
Why do you want to say that before you begin?
Because the judgment has been based on the basically medical report, and medical report is of the 23/13, that is on the day the FIR was lodged. And there is also in the evidence that the minor girl has been tutored by her father.
Yes, go on.
Lordship, there are 8 witnesses. So, Lordship, should I read out the Lordship?
There is to point out infirmity. Anything is there, you point out.
Lordship, that is what infirmity is that, Lordship. If my Lordship may kindly peruse I would like to kindly peruse the FIR first. Because, Lordship, the day of occurrence, the incident as such goes that the minor girl has come from her school, and thereafter her father saw blood oozing out. At first, she didn't tell her father anything, but they took to the hospital, and in the hospital, she confined to the doctor. Now, if that be so, if we go through the FIR, it seems like that is on the same day, that is on 20th. But the FIR says that it happened on 16th. And the judgment also says, the trial court judgment, Lordship, based on PW1, that is the informant, PW2, that is the minor girl, and the victim, and the based on the medical evidence, the conviction has been made. So if we believe the medical and the minor girl in her cross-examination, she has specifically stated that I have been told today, I have told by my father to give the evidence. So we come to the evidence, Lordship. I can show you, Lordship.
Yes.
Lordship, PW1, that is the father. That is the informant and father of the victim. Should I read out, Lordship, or should I just...
That depends entirely on you, madam. Your style of submission, we are not going to dictate.
Lordship, আসামিক চিনি পাওঁ সোয়েনচোৰ আগতে ঘটনা হয় উক্ত দিনা মোৰ ছোৱালী পূজা কুমাৰী লৰ্ডশ্বিপ সোয়েনচো 10 বছৰ সোয়েনচো স্কুললৈ বুলি গৈছিল বাটতে আসামীয়ে তাইক মাতি নি ঘৰলৈ নিয়ে আৰু তাইক লগত বেয়া কাম কৰে পিছত তাই ঘৰলৈ আহি ভাত খাবলৈ বহোতে কৰা ঠাইৰ পৰা তেজ ওলোৱা দেখি মই পূজাক সোয়েনচোক সোধপোছ কৰাত তাই প্ৰথমে নেজানো বুলি কয় Last line is important, Lordship. মই ডাক্তৰৰ ওচৰলৈ তাইক নিও ডাক্তৰে সোয়েনচোক ভালকৈ সোধাত তাই কয় যে আসামীয়ে তাইক লগত দৈনিক সংগম কৰে তাক ডাক্তৰে ৰেপ কৰা কেছ তাইক চিকিৎসা নকৰাত আমি থানাত এজাহাৰ দিওঁ with so-and-so. Then Lordship cross-examination. মোৰ ছোৱালীজনী হিন্দী স্কুলত দ্বিতীয় শ্ৰেণীত পঢ়ে ঘটনা দিনা তাই স্কুলত উপস্থিত আছিল তাইক তেজ ওলোৱা দেখি প্ৰথম বিশ্বনাথ চাৰিআলি চিভিল চিকিৎসা কৰাই পিছদিনা সঞ্জীৱনী নাৰ্ছিং হোমত ডক্টৰ বিকাশ সৰকাৰ দেখুৱায়। Lordship, there is also information.
Just yesterday, late evening, by the Office of the Learned DSGI.
Even the last occasion on the submission made by the Standing Council NCB, Lordship, this matter has been fixed and they have already filed their objection on the last.
Our objections are not on record, my lord. I have checked the file of the Honorable Court. Our objections are not on record.
I am, Lordship, seeking bail on the ground of 479. That is if the undergone prisoner is undergone one half of the punishment, Lordship, that their bail may be considered, Lordship. Petitioner has undergone the period more than, Lordship, half of the punishment, Lordship. There is a proviso also under section 479, Lordship. Their objection mainly on the merit, Lordship, but I am seeking bail because of the under the petitioners have been undergone, Lordship.
I'm afraid to say, my lord, that observation is not correct. Even the FX Court has in catena of judgments held even in cases involving narcotics, where the full-fledged trial has completed, and upon conviction, my lord, there's no longer a presumption of innocence. And hence, my lord, considering the gravity of the offense and like how it affects the public, should not be given here. And my lord, first they should prove there's any perversity in the order or the judgment. On those grounds, it can be considered.
On the last occasion, I had, Lordship, submitted one judgment, Lordship, that is the Satyanan Kumar until, and a categorical observation made by the Lordship Honorable Supreme Court, Lordship. If the appellant, Lordship, has undergone 1/3 or 1/2 of the punishment, Lordship, that bail petition may be considered, Lordship. If there is no possibility of hearing the appellant in their future, Lordship. Because even in the observation also made in this regard, Lordship, that even without any bail petition moved by on behalf of the petitioner, the court can consider considering their undergoing period, Lordship. Lordship, the legal aid matters, Lordship, they could not file appeal immediately after because of their, Lordship, economical condition, Lordship, poor economical condition, Lordship. Has come through the legal aid, Lordship. After some, Lordship, days, perhaps this appeal will become infructuous, Lordship.
My lord may take up after 1 week, my lord. We'll be prepared. I'll place my objections on record, and it can be finally heard in totality.
Both the appellate court has the discretion, Lordship, under section 479 to release the petitioner irrespective of any objection from the other side, Lordship. Oh.
Yeah, put her asile. এইটোতো মানে নৰ্মেলি এনেকুৱা হ'ব নালাগে ট্ৰান্সমিশ্যন নহয়.
Because I have already gone through the office note also. The office has already, Lordship, sent reminder for requisition of the LCR, Lordship. Last office note also.
Fine.
Office notice dated 14/7, so it may have come by today also, we do not know. Verified that.
In fact, there is no fault on the part of the registry. Registry has already sent the reminder on the basis of the order passed by the Honorable Court law. But the trial court.
There was strike.
Yeah, it will come from Lordship, the Kamrup Metro, that is Session Kamrup Metro, Lordship. Last 3 question, Lordship.
Third learned counsel for the petition, appellant and learned. For what?
NCB, my lord.
NCB. As per office note dated 2026, the TCR has not been received by the section. So reminder has been sent. Verify. Lays the matter again on, we'll have it on Tuesday again.
Lord, we may be allowed to place our objections, my lord.
So place the objection filed by the NCB in IA, in the connected IA. That is 445 of 26. Be tagged with the record. And the hearing of the case cannot take place for non-receipt of the PCR or any other reason. IA will be taken up for consideration.
Yeah,